Hello, check.
The condition of organizer that the court proceeding may now commence. Much obliged. May I request the learned counsel?
Hello.
The council seeks permission to address the bench at the lodge. The permission of the court may the council provide the companion. Your Lordship, I'm the counsel on behalf of the appellant. I will be dealing with issue number 1 and 2, for which I shall be taking 25 minutes of the court's precious time, and my co-counsel will be dealing with issue number 3 and 4, along with the prayer clause, for which he shall be taking 25 minutes of the court's precious time. Much obliged, Your Lordship. Your Lordship, the counsel seeks permission to elaborate on the facts of the case. Much obliged, Your Lordship. Your Lordship, the present case is an appeal that has been preferred on the impugned judgment that has been delivered against the CEO, namely Mr. Vikram Seth of Green Horizon Developers. Your Lordship, in this case, Your Lordship, the city of Tripura, Your Lordship, was a rapid urbanization, Your Lordship. Your Lordship, here, the Green Horizon Developers Private Limited was granted a contract by the Municipal Corporation of Tripura to carry on and manage a public-private partnership landfill site at Kailash Puram, Your Lordship. Your Lordship, such contract was done on June 1st, 2025. Your Lordship, there resulted an unfortunate event, Your Lordship, that led to the hospitalization of people and the death of some individuals, Your Lordship. Your Lordship, in that very day, Your Lordship, one meteorological report was published which showed that unprecedented thermal inversion in Tripura, Your Lordship. Your Lordship, coming to the facts, Your Lordship, 3 individuals were died during the event of the Tripura incident, Your Lordship. If Your Lordships are satisfied with the facts of the case, may the council move on to the jurisdiction clause. Much obliged, Your Lordship. Your Lordship, the appellant has approached this Honorable High Court under section 415 of the Bharatiya Nyaya Vyastava Sanhita, Your Lordship. Your Lordship, this provides for the appellate jurisdiction of the High Court to try cases out of conviction of criminal cases in the lower court, Your Lordship. Much obliged. If Your Lordships are satisfied with the jurisdiction clause, may the council move on to the arguments advanced. Much obliged, Your Lordship. Your Lordship, issue 1 pertains to whether the acts of the accused in the context of a PPP model where the state had supervisory duties satisfy the ingredients of culpable homicide, or if the lack of direct intent and the intervening thermal inversion reduces the offense to rash or negligent act. Your Lordship, here the council respectfully submits, Your Lordship, that the conviction of the appellant under section 105 of the BDNA, Your Lordship, that is the Bharatiya Dandaniti Adhiniyam, Your Lordship, is legally unsustainable. As the prosecution, Your Lordship, the erstwhile prosecution, the respondent in this very case, Your Lordship, has failed to satisfy the statutory threshold of culpable homicide, Your Lordship. Your Lordship, the unfortunate incident resulted in the loss of lives. Your Lordship, however, criminal law does not punish an accused merely because a consequence has occurred. Your Lordship, the prosecution must establish, Your Lordship, the consequences occurred with the required mental element and through a direct cause link that is attributed to the accused. Your Lordship, in this regard, the council's submission will be in 3 folds, in 3 arguments, Your Lordship. Coming to my first argument, Your Lordship, Your Lordship, before punishment under section 105 can arise, the prosecution must first establish culpable homicide under section 100. Your Lordship, first, is the 100 contemplates 3 mental elements. The first one, Your Lordship, that is intention to cause death. Your Lordship, the second one is the intention to cause such bodily injury likely to cause death. The third one is, Your Lordship, knowledge that death is likely to result. Your Lordship, in this regard, the first two limbs may be dealt with briefly, Your Lordship. Your Lordship, there exists no material showing that the appellant, Your Lordship, in this case, the Green Horizon company, Your Lordship, intended to cause death or any bodily injury that is likely to cause death, Your Lordship. Your Lordship, the appellant was operating a landfill, it is under a public-private partnership. Your Lordship, after being awarded the contract on 1st of June 2025, it for management of Kailash Puran landfill, Your Lordship. Your Lordship, the purpose of the arrangement was waste management and discharge of public duty. Your Lordship, there was no deliberate release of any toxic gases, Your Lordship. There was no targeting of any residents. Your Lordship, no intentional acts directed towards causing bodily injury, Your Lordship. Hence, Your Lordship, the first two requirements under section 100 can be stand excluded in this regard, Your Lordship. Coming to the third limb of the requirements of eligibility under section 100 of the BDNA, Your Lordship. Your Lordship, the entire prosecution case, Your Lordship, rests upon the third limb, that whether the appellant possessed knowledge that death was likely to occur. Your Lordship, it is respectfully submitted in this regard that this requirement is also not satisfied, Your Lordship, in this very case, Your Lordship. It is the law draws a clear distinction, Your Lordship. It draws a clear distinction between knowledge that there is an existence of a risk and the knowledge that death is a likely consequence. Your Lordship, every industrial activity, Your Lordship, may involve the risk, Your Lordship. Your Lordship, however, section 100 requires the latter, that is, knowledge that death is the likely consequence. Your Lordship, the Honorable Supreme Court, in the case of Keshav Mahindra versus State of Madhya Pradesh, Your Lordship may refer to page number 46 of the compendium. Your Lordship, it held that even in cases involving grave industrial disasters, Your Lordship, culpable homicide cannot be sustained unless knowledge, Your Lordship, specifically knowledge of the likelihood of death is apparent or is established, Your Lordship. Your Lordship, similarly, in the case of Suleiman Rahman Mulani versus State of Madhya Pradesh, Your Lordship may refer to the case provided by the council here, Your Lordship. Your Lordship may also refer to page number 19 of the appellant memorial, Your Lordship. Your Lordship, here it held that knowledge cannot be presumed merely because an unfortunate consequence has occurred, Your Lordship. Your Lordship, knowledge must be apparent, Your Lordship, knowledge must be there. It is the main criteria, the very crux of the third limb of section 100, Your Lordship. Your Lordship, coming to the present case, Your Lordship, the surrounding circumstances actually negate such knowledge. Your Lordship, risk management mechanism was not exclusively controlled by Green Horizon itself. Your Lordship, it was divided, Your Lordship. It was shared between two individuals, two institutions, Your Lordship. Your Lordship, the PPP arrangement, it divided the responsibilities. Your Lordship, the facts demonstrated that during June to November of 2025, Your Lordship, the TDA continued supplying mixed waste. Your Lordship, mixed waste to the landfill, which, while its primary segregation infrastructure was under maintenance, Your Lordship. That is the submission of the TDA in this regard. Your Lordship, further, Your Lordship, hazardous waste, Your Lordship, hazardous waste monitoring as per the PPP, Your Lordship, was retained by the state. Your Lordship, the very monitoring of the hazardous waste in the landfill was monitored by the state itself. Your Lordship, that was not given to the Horizon, that is Green Horizon in this case, Your Lordship. This allocation becomes extremely significant, Your Lordship, because the very substances that is alleged to have converted the incident into a fatal disaster were hazardous industrial contaminants, Your Lordship. Your Lordship, you may kindly refer to Annexure 2, Your Lordship, Annexure 2.
Before that, but coming to the knowledge, you had the knowledge. Knowledge in the sense, if I come to the facts of the case, industrial chemicals found in the landfill were dumped by the unknown tankers. So you had the knowledge. There is some because that has been your plea, that has been your contention before the court, in the trial court below. So you had the knowledge. You never complained before anyone, any authority, be it the state. You never complained before anyone.
Much obliged, Your Lordship. Your Lordship, in this regard, the council submits that industrial chemicals, Your Lordship, it may have been given or may have been dumped by the unknown tankers, Your Lordship. However, Your
That
Lordship,
becomes your responsibility as well.
much obliged. Yes, Your Lordship. Your Lordship, however, Your Lordship, here the council provides that according to the PPP, Your Lordship, the very monitoring, Your Lordship, the very monitoring, Your Lordship, of the hazardous waste monitoring. That is a hazardous waste. Your Lordship, that is a hazardous waste in its meaning, Your Lordship. That is a hazardous waste. It was monitored by the state, Your Lordship. Your Lordship, the Green Horizon was merely given the job to basically fill the landfill, Your Lordship, basically to segregate and process and compost. That was the duty of the Green Horizon, Your Lordship, in this regard. Your Lordship, even when we go to the CCTV, Your Lordship, CCTV footage will also happen, which will be dealt by my co-counsel in the coming arguments, which will solve the queries of the bench to the utmost regard. Much obliged.
Learned counsel, you have referred the court with the case Suleiman Rehman Mulani.
Yes, Your Lordship.
Could you please highlight how this case is relevant as far as when you have cited, and what is the value of this case and ratio in this before this court?
Much obliged, Your Lordship. Your Lordship, Suleiman Rehman Mulani versus State of Maharashtra, Your Lordship. Your Lordship, it was held to be that knowledge, Your Lordship, cannot be presumed merely because that unfortunate consequences occurred.
Can you please cite the line which you are referring over here? in this
Much
case?
obliged, Your Lordship. Much obliged. Your Lordship, in the case of Suleiman Rehman Mulani versus State of Maharashtra, Your Lordship, it was the appellant in this case, Your Lordship, who only possessed learner's driving license, Your Lordship, and who was
How this case is relevant to you,
much obliged.
and
Your
why
Lordship.
this court will follow this full judgment.
Much obliged, Your
This is
Lordship.
also decided by 3 judges bench.
Yes, Your Lordship.
And we are also sitting
Three
over here
judges.
3 judges bench.
Your Lordship. Much obliged, Your Lordship. Your Lordship, here the main principle was to impose criminal liability, Your Lordship. The court held that the death must be direct, proximate, and efficient result of accused rash or negligent act. Your Lordship, here in this very regard, in this very case, Your Lordship, this principle can be applied to show that Your Lordship, that there is no direct, there is no proximate, there is no efficient result, Your Lordship. It is not proximate to what the things or what the events have occurred, Your Lordship. There is no proximate connection with the Green Horizon, Your Lordship. Hence, Your Lordship, such criminal liability, Your Lordship, cannot be awarded to the CEO of the Green Horizon, Your Lordship.
Should I accept learned counsel that you are not trying to answer what this court has placed before you?
Much
Why
obliged, Your
this
Lordship.
court will refer this particular judgment, which was decided only by 3 judges, because on the law point you have to qualify.
Much obliged, Your Lordship. Your Lordship, it was a 3-judge bench of the Supreme Court, Your Lordship. Your Lordship, this is the High Court of Tripura, Your Lordship. Hence, Your Lordship, that authority has binding effect upon this court, Your Lordship.
On all the facts or on the law?
On the law, Your Lordship.
So the facts was different.
Yes, Your
What you are having the fact and what the
Present
case
facts
which you have cited, facts are different.
Yes.
How the law is similar in nature? Can you cite it?
Much obliged, Your Lordship.
At which page you are referring to? Again, I am citing it. At which page you are referring to where you are saying that this principle must be followed by this court?
Much obliged, Your Lordship. Your Lordship may. Your Lordship, the council here submits that the principle, Your Lordship, the principle
At which page number?
much
You
obliged.
have, see, when you have cited this case and you have given me this hand compendium, you should show us at which page number you are referring to, so that means we can get the satisfaction.
Much obliged, Your Lordship. Your Lordship may refer to the page number 2 of the given.
Yeah, go ahead. Para number 10.
Your Lordship, para number. Your Lordship, para number, the council is not aware of the para number, Your Lordship.
Go ahead.
Much obliged, Your Lordship. Coming to the arguments, Your Lordship. Your Lordship, in the present case, surrounding circumstances actually negate such knowledge. Your Lordship, the risk management mechanism was not exclusively controlled, as the council has already submitted, Your Lordship. This allocation, Your Lordship, the allocation that it is divided between the two institutions, Your Lordship, it is significant because the very substance, Your Lordship, the very substance that alleged to have converted the incident into a fatal one, Your Lordship, it is under the very control of the TDA, Your Lordship, very control of the state. Your Lordship, here the council would like to draw your attention to the annexure 2, Your Lordship, provided in the proposition, in the facts of the case. Your Lordship, deposition of PW1, Dr. Ananya Sharma, who is an environmental scientist, Your Lordship. Your Lordship, she conducted soil and air quality tests, Your Lordship, on 16th of December 2025, after the incident took place. Your Lordship, PW1 specifically provided that over 40% non-biodegradable industrial polymers and traces of isocyanides, which according to PW1, Your Lordship, are high-level industrial toxins, Your Lordship, not normally found in waste management, Your Lordship, not found in this municipal biodegradable waste, Your Lordship. Therefore, Your Lordship, the very category of hazardous substances which intensified the incident entered despite the state's monitoring capacity, Your Lordship. The state was supposed to be the monitoring power, Your Lordship, in this case. However, such ingredients, such toxins came to the landfills, Your Lordship, without even when they were monitoring the case, Your Lordship. Your Lordship, this becomes even clearer after the conduct of the TDA itself is taken place, Your Lordship. Your Lordship may kindly refer to the annexure number 2, or the deposition of PW3. Your Lordship, that is Miss Sunita Rao. Your Lordship, Miss Sunita Rao states that the IDA inspectors visited the sites weekly. Your Lordship, they provided all clear logs for November 2025, Your Lordship. Your Lordship, this evidence is very crucial in this regard. Your Lordship, if the hazardous conditions was so obvious, Your Lordship, so obvious that their knowledge of likely to cause death must now be imputed to the appellant, Your Lordship, it is difficult to explain how the state's own inspecting authority, Your Lordship, repeatedly inspected the very landfill, Your Lordship, and certified the facilities weeks before the incident. Your Lordship, the state cannot certify compliance and characterize the same operation as homicidal in December of 2020.
But you terminated her 1 month before the incident took place to save yourself.
Much obliged, Your Lordship. Your Lordship, that works in the council's favor, Your Lordship. Your Lordship, it shows that maybe she has some animosity against the company because of the termination, Your Lordship. However, she provided this very deposition, Your Lordship, that the people from the investigation officer, Your Lordship, they came, they certified, Your Lordship, that is in very regard, Your Lordship, it helps the council, Your Lordship, in order to establish the very guilty mind of the TDA, Your Lordship. Much obliged. Coming to the second argument of the council for issue number 1, Your Lordship, even assuming, Your Lordship, certain operational deficiencies existed, Your Lordship, that alone cannot establish culpable homicide. Your Lordship, the prosecution must prove that the appellant's act was direct and effective to cause of death, Your Lordship. Your Lordship, in the case of Kurban Hussain Muhammad Rangawala versus State of Maharashtra, Your Lordship, Your Lordship may refer to page number 15 of the compendium. Your Lordship, it held that criminal liability requires a direct nexus between the accused action and the death caused. Your Lordship, similar in the case of Sushil Ansal versus State through CBI, Your Lordship, it establishes that the safety violation alone cannot elevate liability unless the required mental element and cause connection exists. Your Lordship may refer to page number 19 of the memorial for this case, Your Lordship. Your Lordship, in the present case, Your Lordship, the causal chain itself is uncertain. Your Lordship, the strongest evidence comes from annexure 2 PW1, the deposition of PW1, that is the environmental, Your Lordship, the environmental scientist, Your Lordship, environmental scientist. Your Lordship, that is Dr. Ananya Sharma. Your Lordship, Dr. Ananya Sharma, in her deposition, said that I cannot definitely say if methane alone caused the pressure cooker effect or if the illegal dumping of industrial waste by unknown third parties acted as the primary catalyst. Your Lordship, the very person who is the expert in this regard is not sure, Your Lordship, what may be the reason, Your Lordship. What may be the reason for such a fatal accident, fatal incident, Your Lordship? Your Lordship, here the admission is very fatal in this regard. Your Lordship, the burden was never upon the appellant to prove an alternative cause. Your Lordship, the burden remained upon the prosecution to establish one clear and legally sustainable causal chain, Your Lordship. Your Lordship, however, the prosecution's own expert, Your Lordship, prosecution's own expert is unable to identify the primary catalyst. Your Lordship, she's saying it might be this, it might be that, Your Lordship. Your Lordship, this admission assumes greater significance when viewed with surrounding facts of the case. Your Lordship, the record indicates presence of unauthorized industrial waste allegedly introduced by unknown third party.
But irrespective of PW1, you actually knew the effects of methane and leachate. Is not that?
Your Lordship,
Irrespective of what the PW1 said, you yourself knew about the effects of methane and leachate.
much
But precautions were not taken, and to the effect that you never complained before anyone. When the government lodged a complaint, even you had the right to lodge a complaint. You did not do that, irrespective of the fact that you knew about the effects of methane and leachate.
much obliged, Your Lordship. Your Lordship, the company in this regard, that is National, Your Lordship, the Green, Your Lordship, the notice was sent, Your Lordship. The notice for money, Your Lordship, funds for repairing the very composting, Your Lordship, Your Lordship, in this regard, Your Lordship may refer to the deposition of PW5, that is the investigator, the IO in this very case, Your Lordship. Your Lordship, when the IO conducted the investigation, Your Lordship, it found various notices sent by Green Horizon to municipal corporation requesting funds for composting unit repairs, which remain unanswered for a year, Your Lordship. Your Lordship, notices were sent, Your Lordship, regarding, Your Lordship, monetary, Your Lordship, funds, so that the repairs can be taken place. However, Your Lordship, it was heard to deaf ears, Your Lordship. The municipality never responded to any of the notices. They never responded to any of the helps and pleas and cries of the company, Your Lordship. It was based on that, Your Lordship, that certain repairs were not being able to take place, Your Lordship. The council seeks permission to move on with further arguments. Much obliged, Your Lordship. Your Lordship, forensic examination conducted after the incident revealed the presence of more than 40% non-biodegradable industrial polymers along with traces of isocyanates. Your Lordship, substances which PW1 herself identifies as high-level industrial toxin not ordinarily found in municipal waste, Your Lordship. Your Lordship, therefore, the prosecution's theory that the deaths were the direct consequences of the appellant's action, appellant's landfills operations, overlooks a crucial intervening factor. Your Lordship, the possible introduction of hazardous industrial waste or industrial substances by the independent third party. Your Lordship, this causes a doubt. Your Lordship, there arises a doubt that this may be a work of a third party. There is a doubt. Your Lordship, when conviction is given, Your Lordship, there should be no doubt. It should be beyond reasonable doubt, Your Lordship, which the prosecution, Your Lordship, in this case, Your Lordship, the lower court, Your Lordship, was disregarded in this matter, Your Lordship. Your Lordship, applying the principle that was laid down in Kuban Hussain Mohammadi Arangawala versus State of Maharashtra, Your Lordship may refer to page number 15 of the compendium. Your Lordship, where the Supreme Court, Your Lordship, held that the accused act must be direct and proximate cause of death, the existence of an independent third party contribution creates substantial doubt regarding the causation, Your Lordship. Your Lordship, the third party being present there, Your Lordship. Your Lordship, this means that there might be some other way, some other hypothesis, Your Lordship. Your Lordship, the hypothesis for the guilt to be established, Your Lordship, hypothesis must be only one, that is the guilt of the accused, Your Lordship. However, Your Lordship, by the production of the the presence of the third party, Your Lordship, proves this wrong, Your Lordship. Coming, Your Lordship, this becomes even more significant because under the PPP agreement, Your Lordship, hazardous waste was monitoring by the state. Your Lordship, the same recourse, Your Lordship, it was expressly retained. Your Lordship, therefore, if hazardous industrial waste was entered into the municipal waste stream, Your Lordship, it demonstrates that the risk arose from an area which was not under the exclusive control of the appellant, Your Lordship. Your Lordship, coming to the uncertainty, Your Lordship, it is further supported by forensic evidence. Your Lordship, timeline records of environment.
Exclusivity does not exclude you. You are equally responsible.
Your Lordship. However, Your Lordship, that doesn't give criminal liability to the CEO, Your Lordship. Criminal liability is attracted only when the hypothesis directly points at the very accused, Your Lordship. Coming to the further arguments, Your Lordships. Your Lordship, uncertainty, Your Lordship, is further supported by forensic evidence. Your Lordship, the timeline records that environmental testing and forensic examination was conducted on 16th of December 2025. Your Lordship, it revealed, as the council already stated, it revealed industrial polymers, it revealed traces of isocyanides, Your Lordship. Your Lordship, these are not ordinary components that municipal biodegradable waste comprises of, Your Lordship. Your Lordship, they indicate hazardous industrial contamination. Furthermore, Your Lordship, coming to the meteorological report, Your Lordship, meteorological report was published on 14th of December 2025, Your Lordship, which showed that extraordinary events beyond operational control. Your Lordship, it showed the unprecedented thermal inversion in Tripura. Your Lordship, thermal invasion in Tripura is basically, Your Lordship, it traps the heat in the ground, Your Lordship, which results in the various incidents, Your Lordship. It is only, Your Lordship, this might also be a trigger point, Your Lordship. This might also be a trigger point for the fire. This might also be a trigger point for what the incidents that has followed, Your Lordship. Your Lordship, its relevance is only to demonstrate that extraordinary events, Your Lordship, beyond operational control were contemplated within the PPP framework, Your Lordship. PPP framework, Your Lordship, it provides for force majeure clause, Your Lordship. Your Lordship, the incident was therefore not the result of one isolated act. Your Lordship, it was but a combination of industrial contamination, it was hazardous waste monitoring failures, Your Lordship, it was unusual atmospheric conditions, it was the other external factors, Your Lordship. Your Lordship, accordingly, Your Lordship, direct cause chain required for culpable homicide doesn't exist in this case, Your Lordship. Your Lordship, even criminal negligence, Your Lordship, criminal negligence was not established, Your Lordship. Your Lordship, in Jacob Matthew versus State of Punjab, Your Lordship may refer to page number 8 of the compendium. Your Lordship, the Supreme Court held that criminal negligence requires gross negligence amounting to reckless disregard for life. Your Lordship, here the facts show absence of recklessness. Your Lordship, a mere lapse or failure of precaution is insufficient in this regard. Your Lordship, the appellant submitted multiple notices requesting for funds, as the council have already stated, Your Lordship. The for composting unit repairs which remain unanswered. The facility was not secretly operated outside the supervision, Your Lordship. Your Lordship, the TDA inspected weekly. All clear logs were issued. Your Lordship, state monitoring mechanisms continued, Your Lordship. However, such an incident took place. Your Lordship, therefore, the facts may suggest operational difficulties, but they do not establish the gross disregard required for criminal negligence, Your Lordship. If Your Lordships are satisfied with issue number 1, may the council move on to issue number 2. Much obliged, Your Lordship. Issue number 2 pertains to whether the Tripura Development Authority, that is the TDA, Your Lordship, is an instrumentality of the state, is liable for blatant violation of the Solid Waste Management Rules 2016 and as an abettor of the alleged offences. Your Lordship, it is respectfully submitted that the TDA cannot escape accountability by portraying itself as a mere regulator or supervisory authority, Your Lordship. Your Lordship, the issue, Your Lordship, in these terms, the violations of solid waste management rules of 2016. Your Lordship, when the statutory framework is read alongside the factual record, Your Lordship, it becomes evident that TDA retained non-delegatory statutory duty or statutory obligations under the solid waste management rules. Your Lordship, the TDA repeatedly, Your Lordship, violated those obligations, the very obligation that was put forward by the rules to them, Your Lordship. The TDA possesses actual knowledge, Your Lordship, actual knowledge of the conditions of the landfill. Your Lordship, TDA's omissions, failures, and materially contribute to the conditions that circumambulated in the incident, Your Lordship. Therefore, the state cannot selectively attribute responsibility, Your Lordship, exclusively to the appellant, that the appellant was liable for the entire incident, Your Lordship. Your Lordship, here, coming to the starting point, Your Lordship, must be the rules themselves. That the rules under the very rules that has been provided under this solid waste management rules, Your Lordship. Your Lordship, Rule 15 of the solid waste management rule, it imposes primary responsibility upon local authorities for planning, segregation, collection, transportation, processing, and environmentally sound disposal of solid waste. Your Lordship, more specifically, Rule 15B, Your Lordship, it requires door-to-door collection of segregated waste. Your Lordship, Rule 15G, it talks about requires local authorities to ensure segregation at source. Your Lordship, Rule 15Q requires transportation of segregated biodegradable waste to processing facilities. Rule 15V obligates local authorities to facilitate and maintain, Your Lordship, waste processing infrastructure, Your Lordship. Rule 15W, Your Lordship, requires local authorities to facilitate operation and maintenance of sanitary landfill infrastructure. Your Lordship, these duties are statutory, Your Lordship. Your Lordship, they arise from law and not from contract, Your Lordship. Your Lordship, therefore, the PPP agreement, Your Lordship, it could not delegate the operational function of the TDA in this regard and could not never extinguish statutory obligations that have been imposed upon the TDA. Your Lordship, the proposition itself, Your Lordship, the facts of the case, Your Lordship, recognizes this continued role, Your Lordship. Your Lordship, the Lordship may kindly note that the TDA retained responsibility for primary segregation infrastructure, which was not provided, Your Lordship, stating reasons that it was under maintenance. Your Lordship, the hazardous waste monitoring was retained by the state. Your Lordship, thus, even under the PPP framework, Your Lordship, TDA remained deeply embedded within the waste management chain, Your Lordship. Your Lordship, the Honorable Supreme Court in Municipal Council Ratlam versus Verdichan, Your Lordship may refer to page number 26 of the compendium, held the statutory authority, Your Lordship, cannot avoid public obligations by pleading administrative inconvenience or resource constraints, Your Lordship. Your Lordship, the very rules provides them with statutory obligation to do the segregation, to collect it, to provide for infrastructure, Your Lordship. However, that was not done in this case by the TDA. Your Lordship, similarly in MC Mehta versus Kamal Nath, Your Lordship may refer to page number 24 of the compendium. Your Lordship, the court recognized that environmental responsibility held by the state are obligations held in trust for the public. Your Lordship, applying these principles, Your Lordship, the TDA could not contract out of responsibilities imposed by the rules. Your Lordship, just because they came into a contract, it doesn't mean they are immune, Your Lordship. They are not obligated by the laws, by the rules, Your Lordship. Your Lordship, the PPP does not mean abdication, Your Lordship. The PPP means participation, Your Lordship. Your Lordship, coming to the second argument of issue number 2, Your Lordship, this case is not an isolated lapse, Your Lordship. Your Lordship, the factual record reveals continuing statutory violations. Your Lordship, Rule 15G, Your Lordship, requires segregation of waste at source. Your Lordship, it has been provided in the facts that Your Lordship, it is provided in the fact that the TDA, Your Lordship, are disposing mixed waste to the landfills. Your Lordship, Rule 15ZH mandates discontinuance of dumping mixed waste. The very rule provides for not dumping mixed waste, Your Lordship. They are violating the very rule that powers them, Your Lordship. Your Lordship, coming to the significance of violation, Your Lordship, it cannot be overstated. Rule 344, Your Lordship, defines segregation as separation of handling of biodegradable waste, non-biodegradable waste, domestic hazardous waste, and other categories of waste. Your Lordship, this was not done by the TDA, Your Lordship. Your Lordship, Rule 357, Your Lordship, it further incorporates the waste hierarchy principle, Your Lordship, which prioritizes prevention, reduction, reuse, recycling, and recovery before landfill disposal, Your Lordship, which is not done by the TDA, Your Lordship. Your Lordship, they are flouting the very rules, Your Lordship. Your Lordship, as a result, Your Lordship, accumulation of biodegradable and non-biodegradable material is precisely the type of risk rules seeks to prevent, Your Lordship. Your Lordship, coming to the third argument, the violations, Your Lordship, become even more serious when hazardous contamination is considered, Your Lordship. The PPP arrangement, Your Lordship, specifically retain the hazardous waste with the state. Your Lordship, this is fully consistent with Rule 15I, Rule 15J, Your Lordship, of the very rules. Coming to, Your Lordship, the TDA, Your Lordship, they cannot claim ignorance. Your Lordship, the proposition conclusively establishes actual knowledge. There was actual knowledge with the TTA, Your Lordship. And the timeline of events also records that, Your Lordship, that the TTA inspectors conducted the inspector. They gave certification, Your Lordship. They were aware of the facts. They knew what was going on, Your Lordship.
Can you plea ignorance?
Much obliged, Your Lordship.
Can you plea ignorance like TTA?
No, Your Lordship. The council cannot plead.
You cannot plea ignorance as well. So same responsibility cast on you as well.
Yes, Your Lordship.
You did not complain anywhere.
This also establishes that they are having the knowledge about the culpability also.
Yes.
They were proposing for the
Yes.
first issue.
Much obliged, Your Lordship.
So you are contradicting your first issue with what you are proposing right now.
And also that you are trying to take shelter by the deposition of DW2 so that you need not have to pay any kind of compensation to the victims, nominal compensation to the victims, trying to take shelter upon DW2.
Much obliged, Your Lordship. Your Lordship, here the council submits, Your Lordship, that this was this event that happened, Your Lordship. It was not only because of the fault of the accused, Your Lordship, not only because of the fault of the appellant, Your Lordship. It was because it was a combination of every single person that was a part of the PPP, Your Lordship. Your Lordship, even the
What you have stated right now, I'm just proposing over here that are you praying before this court that your party must be punished, but along with that, TDA may also be punished. This is the only what you are trying to pray?
No, Your Lordship. In that regard, Your Lordship, that submission by the council was in regards to the criminal prosecution, Your Lordship. That there must not be any doubt, Your Lordship. Hence, the criminal liability of the appellant, Your Lordship, in this case stands null and void, Your Lordship. Much obliged, Your Lordship. Coming to the arguments, advanced, Your Lordship. Your Lordship, the prosecution, Your Lordship, they seeks to construct a narrative in which Green Horizon alone bears responsibility. Your Lordship, the facts do not permit such a conclusion. If Your Lordship may allow me, I wrap up.
Very quickly.
Much obliged, Your Lordship. Your Lordship, the Honorable Supreme Court in EP Royappa versus State of Tamil Nadu, Your Lordship, they held that arbitrariness is unethical to equality, Your Lordship. Your Lordship, arbitrariness is precisely what has occurred in this regard, in this case, Your Lordship. Your Lordship, the state seeks to prosecute the public concessionaire, Your Lordship, that while discharging its own continuing violations, Your Lordship, of the statutory framework, that is the rules, Your Lordship, and such selective attribution of blame is inconsistent with constitutional accountability and the factual record before this court, Your Lordship. If Your Lordship was satisfied with issue number 2, may my co-counsel present on issue number 3 and 4. Much obliged, Your Lordship.
Commission to oppose the highest motion. Much obliged. Permission to initiate issue 3 and issue 4 in front of the Lordship. Much obliged, Your Lordship. Your Lordship, issue 3 primarily deals with the question whether the logbook B and the tempered CCTV footage seized by PW5 investigating officer meet the stringent certificate requirements for electronic evidence and whether the chain of custody was broken during the 48 hours delay in sealing the site. Your Lordship, we start the very first submission that the non-compliance with section 63 BSA renders the electronic evidence inadmissible and fatally undermines its evidentiary weight. And why do I say so? Your Lordship, I argue that whenever there is an introduction of all these records, especially electronic records, it's a strict mandatory requirement of section 63 of the BSA, the Bharatiya Sabut Adhiniyam 2023, which exactly also correlates with the section 65B of the Indian Evidence Act, Lordship 872, that there has to be the production of the requisite statutory certificate renders this digital, and in failure to do, it renders the digital records legally inadmissible. Your Lordship, when you talk about this CCTV footage again, Your Lordship, this has been actually collected by the investigating officer, PW5, and may I request the bench and Your Lordship will collect it to kindly go to the annexures and with the PW5, and it will be in the Moot propositions, page number 7. And they themselves, the Inspector Arjun Barma, the investigating officer, have argued that I conducted a raid on the facility. I say it's the logbook, but the digital timestamp for the CCTV footage shows a 4-hour gap on the night. shows a 4-hour gap on the night of the incident. So there are two things involved here, Lordship. A, Lordship, the statutory certificates are not collected, and B, on top of that, there also remains a 4-hour gap, and there's a gap of the CCTV footage on the very night of the incident, Your Lordship. Your Lordship, here again, Your Lordship may refer to the page number 25 of the memorial and the compendium, page number 37. We have the classic case Arjun Pandit Rao Khotkar versus Kailash Kushan Rao Garantial. And we will see that there is a very settled position of the law regarding the admissibility of electronic evidence in India. The court held that certificates are required under 65B, now section 63 BSA, and it is an absolute mandatory condition, Lordship. Further, again, addressed in Anwar PV versus PK Bashir, again, can be referred to the page number 35 of the compendium, and in the memorial, page number 25, I have taken the exact words citing from the judgment. The certificate required under section 65B4 is a condition precedent to the admissibility of evidence by way of electronic record. Oral evidence in the place of such a certificate cannot possibly suffice. Your Lordship, it is very clear that this evidence they're talking about, the logbook, first of all, it does not have the statutory requirement of the certificate, Your Lordship. Secondly, there also happens to be a gap of 4 hours, Your Lordship. This 4-hour gap again brings questions. The questions are: is this enough? Is this enough to require to establish any beyond reasonable doubt? Is this enough to argue that somehow we were responsible and solely responsible for what happened in the site at the night on which the FIR was registered, Your Lordship? That is the fire that broke out. According to the Moot propositions, are we alone responsible? So are there any third-party involvement? Because we are saying there are third-party involvement, and sadly there was a current failure. There was current for 4 hours. Even we couldn't get the exact people who got involved in the process. So when the fire got ignited, the fire got burst out, there will be many possibilities for the ignition of the fire of the fire, Your Lordship. And here again, may I kindly request the Lordship to go to the annexure again and look at again the PW1, Your Lordship. Again, these are again prosecutions witness, and even she clearly argues, Dr. Ananya Sharma, who says that she's an environmental scientist, and she said that she conducted a soil and air quality test on December 16, Your Lordship. Your Lordship, here the fire broke on 11:30 p.m. on 14 December. The sample was collected in December 16. During this timeline period, a lot could happen, Lordship. And as the samples are being collected, here again, she herself again argues, and have already been argued by my previous counsel, that while the methane levels were high, which are not, there are also isocyanates, which are not typically found in the municipal biodegradable waste. So these are highly labeled industrial toxins, and she cannot definitely say that the methane alone caused the pressure cooker effect. And again, the pressure cooker effect again becomes important, Your Lordship. She herself talked about a pressure cooker effect, which got created because of a thermal inversion, which is again effects of the case. Now, thermal inversion again is a natural process where actually the
Counsel,
yes.
Would you like to tell the court that if the sample of air and soil would have been collected on 14th itself, then the percentage of non-biodegradable industrial polymer would have been high, much more high.
Could have been even low. That Lordship, there's a possibility that there could be temperament. That's what I'm saying. There could be a possibility that third-party strangers are also could be responsible to try to vindicate us. So this could also be an attempt to use our company to use our CEO and to use Horizon developers as an scapegoat for what has been happening in the space. As we say, Lordship, we have already established CCTV camera to monitor the region. But however, although the duty primarily remains,
you said that there was a gap.
There was
the collection of sample. Please come on that.
Yes. There was a 40-hour gap, Your Lordship, which means there's a possibility of even tampering of that evidences. There's also a possibility.
Tampering is different thing.
Yes.
You are talking about the gap in collection of sample.
40 hours,
which
yes.
has not given the true, which is not reflecting the true.
True. Yes, Lordship.
Result.
Probably
Please satisfy this court on that ground, that what would be the possibility, and if the sample would have been collected on time, then what would be the percentage? Because you can see something effect has also been seen in that particular.
Yes.
state.
So, Lordship, here the possibility would be that maybe the industrial toxins could have been less. And why this is also important, Lordship? Because the methane and the isocyanates, the plastic polymer, they collectively, all these things together. This is again deposition becomes important, Lordship. We have this again. The thermal inversion that has been happening, and then we have also the toxicologist who talks about it. This is also a collective effect. There was the industrial polymer, there was the natural cause, and there was the methane. Now, when there's so much of there's a gap, we do not know what else exactly happened. There is a possibility all these things collectively ignited the fire. There's also a possibility some third party role was involved. who attempted to ignite the methane, who attempted probably. This is possible. What we are saying, Lordship, the fire that got ignited, the industrial polymer rate that went high, which is not usually found in municipal biodegradable waste. And we have argued that there are trespassers. There are trespassers who has done that. There's more possibility that suddenly 4 more trespasser big trucks came and dumped it in that time frame, in the time frame of.
You had the knowledge of the trespassers, even then you did not inform anywhere.
Lordship, we did. That's primarily the reason why we installed the CCTV, Lordship. We started primarily this duty of monitoring the space. Realized
When the PW1 environmental scientist, she stated that about the methane and those substances,
yes, Lordship.
is there requirement of any CCTV footage? Because the emissions could prove everything.
Yes, but Lordship, what was also important that area, assuming that it was a site of an incident, the area should have been sealed. So there has been a lacuna done by the investigation officer. The fact that area was open for interaction for everybody. It is true, I understand the fact and empathize that it was a disaster situation, but even then proper police mechanism would have been there. The moment it gets triggered, the moment it is a disaster, the moment the people have already, a fire has been lodged in regards to that place, it is much more requirement that there should have been proper police should have been there, and there should, along with the CCTV which we are doing, we cannot foresee all possibilities, Lordship. The power failure was not in our consideration, just like the thermal inversion of the nature was not in our control, Your Lordship. And even in that clause, Lordship, the force majeure, which also often colloquially referred as act of God, Your Lordship, which basically we were not responsible for this unforeseen circumstances we never imagined. And that is also equally responsible for this, partly for the ignition of the fire. So what we are collectively saying, Lordship, this entire chain is not strong enough to collectively, it is an attempt to vindicate us, to make us the only scapegoat for all the situation that has emerged, which has emerged for many reasons. There are multiple reasons that got involved, and a thing happened. And the only person who is at court, the only person who got the impugned order at the lower court was us, Lordship. And the reason we are here is because not only we are an equal responsible citizen, and we are honorable company, and my client is an honorable man, and he's an innocent man. We could afford technically, we could have afforded the mere nominal damages. But it is not just about the damages, Lordship. It is about calling us making us the scapegoat, and making us look like the sole responsible person for this entire situation, which was completely unforeseen. And this is exactly where we go back, and I connect this entire argument to the issue 3, Your Lordship. That being the non-compliance with Section 63. The logbook which has been used, which technically is tempered CCTV footage, the PW5 argument, investigating officer also remains in lacunae in seizing the whole thing and providing police protections and making sure the sampling collection has been done after 48 hours. At that time, along with the duty of the company, it is also duty of the police to make sure that the area is properly securitized. That was not done.
Coming to the logbook B.
Yes.
PW3 alleged that there are some bribery allegations by you to the state officials. Now, during trial, you never pressed for an inquiry on that bribery allegation on you.
Much obliged, Lordship. Actually, I was coming to the PW3 specifically on the issue 4, but I'll still address it even now. We have seriously contested the very nature of the submission that has been made by PW3, that is Miss Sunita Rao. We clearly see this is a hostile witness submission, Your Lordship. Your Lordship, why do I again say so? Lordship, she resigned in October 2025. But once she resigned, she makes arguments about that she has internal memo. Interestingly, she says she has internal memo showing that the waste management machine was broken and apparently funds were diverted to other projects instead of repairs. When these things are in the lower court, why didn't she submit the memo? She never did. And which is actually why it's important, Lordship. There was non-application of the judicial mind, and we see there has been a violation of our rights. And this when these deposition or prosecution of witnesses were actually cross-examined, we believe there was a non-application of judicial mind, and there was a flaw on the judgment, and it goes away from natural justice. Again, in Sunita Rao, when she says the CEO bypassed the protocol, but then she also says IDA inspectors visited the site weekly. She also mentions that inspectors have given all clear logs for November. That's very interesting. She's also contradicting herself, but she's also saying public officials are saying it's all okay. But me, like Sunita Rao, who is in a litigation, she argues, she was in a lawsuit. She happens to know what happened in November when she resigned in October. It's a factual gap. Although the argument that the police, the government officers is on our interest, But what we are contesting is the nature of the submission. We are in complete cognizance of the law. We haven't violated any law. But what we are questioning is this vexatious nature, this double-sided argument, where she gives partly true information, but using the true information, she also gives a false information, and which is what we are contesting. That this submission of entire Miss Sunita Rao becomes very, very integral, because the sole argument against the issue 4, where the CEO is brought into this scene in this whole case, the primary lynch anchor lies on the submission of PW3, the witness, and we are contesting the very submission of this PW3, and we are saying it is invalid, because there is high possibility that she also had the mens rea to go for a vexatious litigation or to conspire against this. And it's clear, even the submission itself, there are double conversations. She, again, may I reiterate, Your Lordship, humbly, she resigned in October 2025. But she is claiming having knowledge on what happened on November 2025. So she is forcing the future. Technically, once she resigns, she'll lose access to the space. That is one thing. Although the interest is on our interest on what she talks about.
Whatever you have said, it is admitted, accepted, fine. But bribery is a serious allegation, and that remains till now. It is unanswered because you never pressed for any inquiry.
No, Lordship, because we denied, because we know this is a vexatious lawsuit against us. We know we have already have the submission from the. We accept the submission that yes, all police officers said that everything was clear. We are in the rightful process of the law. We are already following the law. But we are saying this is just random allegations coming. And if we start going for, Lordship, we are a company operating. If we go for every single allegations of every single employee, it is not possible for us to go around. We will be simply running on litigations and never be actually able to do our actual job, that is to provide the services that we are supposed to provide, Your Lordship. So that is another reason. So here again, Your Lordship, I'm humbly, very clearly contesting all the submission made by PW3 because she remains to be a hostile witness. Here, Lordship, again, may I kindly, since this argument already connects me to the issue 4, may Your Lordship connect here again. There's this argument about how this investigation lapses also comes in terms of how do we prosecute investigations, Your Lordship. For example, Your Lordship, especially when we have may I refer to page number 30 of the memorial and compendium page number 50K. There's a case called KK Ahuja versus BK Boda. Here again, Lordship, the prosecution cannot selectively champion the uncorroborated testimony, as I cited, of an interested ex-employee while simultaneously ignoring the official administrative validation issued by the state's own regulation apparatus, Lordship. So this is exactly where we completely clearly, on written submission, discard everything that has been argued by PW5. Your Lordship, again, now quickly touching what's remaining in the issue from the issue 3, Your Lordship. Your Lordship, again, we have talked about that there's already been, we are questioning the lack of certificate, Your Lordship. We are questioning the 48-hour delay, Your Lordship. And we also make a submission on a case called Tommaso Bruno versus State of UP, where this 4-hour gap, in regards to the gap, and it argues that when there's an unexplained gap in evidence, Your Lordship, the investigating agency should lead to an adverse inference against the prosecution itself. And on that, may I humbly make a submission, Your Lordship, on the Tommaso Bruno case, where it could be clearly referred in the para 13 and 16.1, Your Lordship. So here again, that this whole debatable, the moment there is reasonable doubt, the moment there is a gap in the evidence, there's a moment there is a gap in the prosecution's engagement with the evidence collection, Your Lordship, that evidence in itself becomes inadmissible and it becomes questionable. And it is exactly where we also question the chain of custody. We have also questioned the submission that comes from Ananya Sharma, who make the sample after 48 hours while the area was still not sealed and the area was accessible to many people. We have also made a submission, Lordship, on PW5's role, the investigator officer, Inspector Arjun Burma, how he also failed in securing that area and providing security for the next 48 hours while the samples may be done. In collection of all this submission, Your Lordship, we submit that this logbook and the tempered CCTV footage, these things are not enough to establish a chain of custody, and hence it is broken, and thereby we do not see there's a connection that shows us to be in the proximate reason for the entirety of the thing that happened. If Your Lordship is satisfied with issue 3, may I approach towards issue 4? Much obliged to Lordship. So, Your Lordship, issue 4 clearly engages the question whether CEO Mr. Bikram Seth can be held vicariously liable for the death caused under the principles of alter ego, or if the failures were purely systemic, institutional, for which only the company as a juristic person can be liable. Your Lordship, here again, we will still start our submission again from the idea that how do we actually exactly Bikram Seth comes into picture, Your Lordship. The primary argument around Bikram Seth Lordship comes from the introduction of Bikram Seth comes from the submission of PW5, Your Lordship. PW5, we have already contested that in terms of the evidence that is collected from Sunita Rao happens to be very conveniently made. She makes she resigns in October, she makes a convenient delay, she waits for an incident to happen. And once the incident happens in December, now she comes up and makes an allegation.
No. You waited. You knew that something is going to happen. That is why you dismissed Sunita Rao.
Lordship, she resigned. We didn't fire her.
There is always in the companies, you can see always you forced to resign, and it is always shown that she resigned. You knew something is going to happen.
Lordship,
That is why you forced her to resign.
much obliged, Lordship, but there is a benefit of doubt, Your Lordship. We accept the Lordship, but it cannot be proved beyond reasonable doubt. It is an allegation, Your Lordship.
And you also did not allege, as I have been repeatedly saying, the serious allegation of bribery. You never
Yes,
did
Lordship,
anything
our
else.
submission is very clear. We see Sunita Rao as a much interested party going for a vexatious litigation. We clearly submitted, Lordship. If we start going for every single party who makes an allegation for us, it's going to be a very costly litigation and it would be misuse of the precious time of the court, Your Lordship.
You think about costly litigation at the cost of the parties, at the cost of the people who are dying.
No, Lordship. Lordship, this is a Lordship, primary Lordship. We didn't come for this. We approached the court, Lordship, only after we have been ruled against. First of all, the trial court, where we feel our rights were violated. Secondly, Lordship, another reason why we came to the court, because we are equally a victim of the structural limitations and the structural mistakes done by the state and the parties involved with the state. That includes even the organizations, municipal corporations, municipal party who is equally responsible for doing their part of the job. And the deposition with Ms. Sunita Rao, we didn't go for her, Lordship. She came against her. She came for the deposition. So the initiation happened from her and Your Lordship. We agree, Your Lordship's point that there is a possibility that we made her forced to resign. But Lordship, there is also a possibility that she did it on her own. So it cannot be proven against us beyond reasonable doubt, Your Lordship. So now, Lordship, again, as I move forward, Lordship, may I also bring in here an interesting case, Lordship, and it's an SK Alag versus state of UP, Lordship, where it says that criminal proceedings against a managing director, emphasizing that penal status must be strictly constituted, cannot be expanded through judicial interpretation to include vicarious liability, but the legislature omitted it. And why do I say so? Lordship, when we talk about criminal liability cannot directly come for, like, if a company makes a mistake, we could not immediately go for the CEO. There has to be some directive mind. There has to be some direct role in some sense of the mens rea that the CEO might have to show. It could be proven that somehow the CEO is actively involved in that act, and only then we could go for a prosecution, Lordship, directing towards the CEO. And this is exactly where, Your Lordship, we again go forward, come for Sunil Bharti Mittal versus Central Bureau of Investigation, Lordship. The court meticulously established that while the criminal intent of individual directors can be attributed upwards to the company to hold the juristic person liable, the reverse is strictly, absolutely prohibited. The doctrine cannot, under any circumstance, be used to reverse and hold directors individually liable for systemic acts. And this is the case of Sunil Bharti Mittal, Your Lordship. And it could, and the exact para would be para 12 and para 14 sub para 4. And I read the exact quote, quote unquote, a corporate entity is an artificial person which acts to its officers. If such a company commits an offense involving mens rea, it would normally be the intent and action of that individual who would act on behalf of the company. However, the reverse is not true. The principle of alter ego cannot be applied in reverse so as to make the directors liable for the offenses committed by the company. Here again, Your Lordships, the CEO Bikram Seth remains to be in a more of a managerial position. He is in a much more higher position to know the exact day-to-day activities of the company in every single sequences. First of all, it is no way at some point could be proved beyond reasonable doubt. It was solely our responsibility. And even on that, Lordship, many other acts of third party, dumping done by trespassers, the environmental situation where thermal inversion could have happened, all these things.
Your CEO establishes everything to look after your company.
Yeah.
Now, you are being vicariously liable for the negligence, because your negligence being on the part of the fact that you did not inform anything about the trespasser tankers.
No,
So you are like for the negligence, you are vicarious liable, and your CEO establishes everything, all institutional things.
Yes. Much obliged, Your Lordship. It is true. The CEO is responsible for the compound and he's overall looking at it. But Lordship, he cannot be held guilty for every single minor event which he cannot be. He is not there all.
This is not minor. People died.
Yes, absolutely, Lordship. But people didn't die because of the CEO. People died because thermal inversion happened, because trespassers came. Trespassers put.
Learned counsel,
Yeah.
please come on this point. Do you believe that the company is responsible for criminal liability?
No, Your Lordship. In this instance, the specificities of this case, we are not responsible for
I'm
criminal
referring to PW2.
PW2. Yes,
Rajesh Kumar, please read it out.
we complained to the developers multiple times. May I submit, Your Lordship? Can I also make an argument with the PW2? Yeah. Lordship, here again, it was very interesting. Rajesh Kumar, I was coming to this witness. Rajesh Kumar is also very interesting person. Here, there's also probably, first of all, yes, Rajesh Kumar did make allegations and we did try. Now, his versions are debatable. And why do I say so, Your Lordship? Not everything that Rajesh Kumar has said under deposition, under oath, can be considered. It again, I argue, Your Lordship. Here again, interestingly, in PW2, Lordship, very interesting. In regards to his son, he says, and Your Lordship, I refer to the page number 6 of the Moot proposition, annexure 2. My son couldn't breathe. He died before we reached the hospital. Very clear, Your Lordship. Now, if we move back a page and try to look at the F2 page and look at the FIR, where Mr. Rajesh Kumar writes in a FIR, Lordship, he says that on reaching home, I found my son facing serious difficulty. Paragraph number 7. I found my son facing serious difficulty in breathing. Okay, then consequent 8. Within an hour, the ambulance reached to our locality and carried all the affected persons, including my minor son. 9. That after being hospitalized, the due treatment of my son started in my city hospital, but in spite of all medical care, the concerned doctor couldn't save my son's life. There's a difference of what I'm saying, Lordship. Not everything,
I'm asking you on PW2 statement.
Yes.
Yes. When he complained of the developer like that, there was multiple times about the foul smell and dark liquid lethal following out the boundary wall. They ignored us. What is your say on this?
Lordship, what we're saying is that, first of all, we didn't ignore them. And secondly, Your Lordship, here we are categorically saying that there is a high possibility that he is making a perjury and making double remark that this witness, every word this witness says cannot be taken on face value, because this witness is telling one thing even regards to his son.
See,
when it's
we are not going to convict a person solely based on one witness statement. There is a circumstantial evidence also, right?
yes.
Can you ignore there was no fire?
So there was fire, Lordship, but we are not the one responsible for the fire.
Can you ignore what is your responsibility? If the fire was there, what was your act as of a company if there was a fire? Because that particular place was under your jurisdiction, right?
Yes.
So what was your act on that?
Your Lordship, first the people who were there, first thing we try to douse down the fire. We try to take down the fire. It is our primary act. And the emergency service
On
also
the fire or to remove all the evidently values? Because you said that means 48 hours, within the 48 hours, the site was not sealed. So even you are also having the lots of opportunity to visit the site and remove all the evidential values.
Absolutely. Much obliged,
So
Lordship.
when you are pointing the finger, first of all, see that means what was your responsibility. And here we are sitting over here to judge what was your responsibility and can you be different from that also or not?
Yes.
Legally,
Yes.
not factually, legally.
Much obliged, Lordship. This is exactly much obliged, Lordship. Again, Your Lordship, my humble submission here is the law is a precise endeavor, Lordship. Precisely, we couldn't be targeted that we were involved. It is true. There is a possibility an argumentative narrative could be drawn that we could also use this time to either douse the fire or we could use this to destroy the evidence. But then this equally holds true for every other party. It could also go for the state who remains also a party to this situation, who could also be doing the same thing. The trespassers, the act of third party, the Tripura Development Authority or the officials. A lot of people could do a lot of things.
Board will look into that matter also, to
Yeah.
what extent the TDA can be held responsible or not to be held responsible. Here, you please plead to what extent you can be exonerated from your responsibility.
So, Lordship, our
How?
yes. So, Lordship, our submission here is very clear, Lordship. What happened was something that happened. I mean, first of all, let me clearly submit, Lordship. What happened was a tragedy. It was definitely a tragedy. People died. We acknowledge, but it was not just us. It was more. It was more a situation of a Lordship. It could be seen like it's a big car that was running when we happened to be one of the element in it. But if we alone were there, this incident would not have happened. But this happened because so many other things also equally were corroborative in this event. And they were happening independently. They were not in our control. The act of strangers are not in our control. The environmental force majeure was not in our
What
control.
I can understand from your para number, referring to your issue number 4,
Yes.
with reference to 4.1,
Yes.
I'm referring to your para number 40, 41, 42, 43, 44.
Yes.
So you're intending to segregate the liability of corporate entity and its officer in
Yes.
the entire paragraph.
Yes.
I'm accepting it.
Okay,
That
yes, much
officer is not liable.
Liable.
I'm proposing that means officer is not liable, but the company is liable. Are you agreeing on this?
Your Lordship, the company is the liability of company would be emerged when we could be directly connected.
Please.
Yeah.
Para 40, 41, 42, 43, 44.
So
you have
it-
not stated anywhere that the company was not liable.
So
You
Lordship,
are only trying to segregate between the liability of your client Vikram Seth and the company.
much
And on this point, I just want to understand legally, not factually, legally, that if the company can be held liable, in that case, what is the liability of Seth? Or if the company can be held liable, and if suppose Seth, I'm accepting your argument that Seth cannot be held responsible, then who can be held responsible from your company? This is my question. Legally, please don't argue on factual basis.
so in regards to company Lordship, there what at this point we have to see who are the people exactly at the grassroots.
Please don't make an argument on the basis of fact. Please make an argument on the basis of law.
Yes.
That if the company was held responsible,
If the company was held responsible.
yes, then who can be made responsible? Which officer of the company can be held responsible? Can
The-
you held a peon for such kind of an incident applying in your case?
Yes, much of his Lordship. Your Lordship, the person who would have the access or authority to direct the will of the company would be the one who could
Who was that? Who can direct the will of the company?
collectively, it let's say in terms of matters
Board
of
of directors.
Lordship.
Board of directors.
Lordship, may I, this is where it becomes important for me to also argue along with making the talking about the law. Because here, from a very legal academic point of view, Lordship, yes, people who are in control of can direct the will of the company. That could include the managers, that could include all people, the public officials. But this Lordship is along with being an academic, the law always has an academic point of view to it. In litigious point of view, in litigation point of view, yes, absolutely. So, but Lordship, much of less to establish the jurisprudence, Lordship, it is also very important, Lordship, that collectively we also have to apply the judicial mind considering the specific facts of the case. As your Lordship have rightly pointed out to the previous speaker, whenever we even cite the case laws, you also asked about the case facts, which is rightly, very rightly, your Lordship has asked. The reason, because your Lordship, the law principle is there, but the principle also has to be taken into cognizance with the facts of the case, which your Lordship has also asked, and we rightfully accept. At some point, we are not being able to provide it perfectly, but we accept. The facts are important, Lordship, which is why here also, Lordship, the facts. No, Lordship, we are accepting that facts are important. Legal principles and facts collectively drive the direction of jurisprudence, Lordship. I mean, and hence is why here the facts being that multiple things collided together for one incident to emerge. In that situation, the company is not somebody who is liable. The company is a party of a situation to which the company didn't have independent control of the situation. We were not in an independent control of the situation. We were dependent on so many people. When it comes to the running the land filling, we are connected with the state, we're connected with the TDA, we are also dealing with trespassers, we are trying to remove it, we are dealing with that.
They can be held vicariously liable. So vicarious counsel, what is the meaning of it? That if someone is held liable, so on his behalf, who can be held responsible?
Yes.
Can you apply the Solomon versus Solomon, or many cases which has been decided on the basis of separate or separate corporate entity?
Absolutely. Lordship, we agree that vicarious liability might emerge when there is a direct proximity or direct connection to the incident. Here we are questioning that very point. We are not directly in link to the situation. We were made to look like a link by many other parties who are equally were responsible, if not equally, more. The possibility lies that they may be even more responsible than us. We happen to be in more like an intermediate situation where we are involved in land filling. We are already installed CCTV.
My last question to the appellant.
Yes.
Do you admit negligence on your part? Tankers, trespassers. Do you admit negligence on your part?
Not willful negligence, Lordship. Not out of will. We tried to stop them. At nowhere in the proposition it will be proved otherwise that we didn't.
Willful cannot be, negligence cannot be willful. Negligence is negligence.
Lordship, yes. Whenever trespassers came, Lordship, it is the fact that we have installed CCTV cameras, it means we do really care about security. Otherwise, why would there be cameras in our vicinity, Lordship? But attempt at all these things could always be bypassed because current failure. For 4 hours, current was not there. At that time, if somebody with a criminal mind comes to trespass, they could always find.
You have not explained that there is not current, no camera, that is incidental or coincidental.
Lordship, I would say it is not definitely incidental, and I think
That is coincidental.
a very random coincidence, Lordship, actually.
Okay.
And it is not incidental and accidental, and this is something I agree with. The Inspector Arjun Verma is also saying that it's a matter of sheer systematic failure. I agree with the public official's deposition here. He said that the soil and gas samples were there, although there's some part of him which were debatable, but I agree when the police official himself says, even in the FIR, where he says it's a sheer systemic failure. So it's a system operating. It's a large organism, the state, the non-state, the people collectively. Some people might have tried to use the situation to get some benefit out of it. So many things are happening. IO's
statements are not final decisions. This is to be decided by the court.
Yes, Lordship, I am just making a submission. This is just an argument. Everything that the honorable courts hold, I truly remain bounded by it, by nature, by will, and by honor, Your Lordship. That is always there, forever there. But the attempt to come to the apex court, because Lordship, we humbly feel, and before I have majorly engaged all the issues 3 and 4, but also like to humbly take the precious time of the court to also to go and engage in detail very quickly, Lordship, with the annexures, because primarily this case is built, and since the annexure is there, primarily this case is built around FIRs and all these depositions that the prosecution has come, and I also have some deposit. I want to critically look at the witnesses and the deposition of the defense, make a contrast analysis with the permission of your Lordship. Much obliged, Your Lordship. So, Lordship, now when we look at we go with the FIR copy. We have the charge sheet. In the charge sheet, and we see that, of course, forensic laboratory confirmed the presence of high concentration of methane and toxic leachate. This is again interesting because here methane is us, toxic leachate is not us. So at the charge sheet itself, there is an acceptance that there are some other things involved away from us. There's one thing already available in the very prima facie, looking at the annexure 1. This could be seen in the Moot proposition, page number 3. Now, when you go to the exhibit 1, page number 4, Your Lordship, again, the information report by the official in charge was Kailash Puram, and this was made by Rajesh Kumar, son of late Mr. Ankur Kumar. So he also, very interestingly, Mr. Rajesh Kumar comes up and talks about, yes, there's a foul smell coming up. He talks about he was returning home on a hectic day. He sees the fire, and his son found his son. These are all his words, his verbatim. And then we go forward and we see that he talks about the death of his son. And here in the FIR, he talks about that how the son eventually, his treatment of his son started in the hospital. But in spite of all medical care, the concerned doctor couldn't save my son's life. I accept it. Like this ninth pair, I accept it. This is what he says. Then we go forward and go to page number 6, Your Lordship. Mr. Rajesh Kumar again comes and makes an submission in front of the court. There is a deposition of as prosecution witness, PW2. Here again, he talks about foul smell, same thing, accepted. But he talks about that my son couldn't breathe. He died before we reached the hospital. Now, what is said in the there seems to be, and this is something not a simple thing, Lordship. This is a son who has died. A father is talking about the son. It raises a serious doubt. How could a father, be double-minded in terms of the very specifics of how the son died? And it is not something, it is huge. Whether the son died before reaching the hospital or whether he went through the entire process where doctors tried and couldn't save. These two things are very different narrative, and it is not some stranger's incident that could be easily forgotten. This is somebody's son. This raises doubts on the kind of arguments or submissions Mr. Rajesh Kumar is making. So there emerges doubt. What could be and how much motive could be there? I'm not denying what happened to his son, but I'm denying the interest with which Mr. Rajesh Kumar approached the court to come and become a witness to this case. Could it be more than just seeking justice for the people? Could it be more to use the... Could it be? I'm not saying it is. But the question emerges, could it be that he has more motive to it, interest to it? Because he is changing his bandwidth of conversation with something so crucial as his son's death. So, because this is a very interesting thing. This is an aggravation. When somebody says died before reaching the hospital, there is no chance he could be saved otherwise. That is very aggravated situation.
Learned counsel, Mr. Rajesh, is he your employee? Is he your employee?
No, Your Lordship.
No. Is he anyway connected with PW3?
No, Your Lordship.
No. So he's an independent witness
Yes.
and he suffered. So what is the wrong if he is becoming a witness?
There's much obvious. There's nothing wrong. But Lordship,
And along with him, 2 other persons have also died.
absolutely.
And 62 were also injured.
Yes. Lordship, to that is also coming. There's also a very interesting possible argument. This comes from the... This is why I was cross-examining all the depositions, Your Lordship. Because while one of the doctor... I will just head ahead because to address this question, in PW4, the chief medical officer of the city hospital, she says that yes, inhalation of toxic byproduct methane, combustion with burning plastics. So burning plastics is not us, but we agree that methane in combustion with burning plastic led to individuals die, including a minor. 3 people died, including the minor, including 3 people. So with toxic pulmonary edema. But then when we go forward to the deposition of deference witness, we have a toxicologist. There's a doctor, who's a city hospital doctor, but now we're going to specifically toxicologist, Dr. Linda Gomes. Linda Gomes also said 3 people died, significance with pre-existing respiratory disease. And now why these things becomes important, Lordship, when we deal with this kind of cases, when we're dealing with justice, we're talking about equity, compensations, we also see to what degree...
Conducted an independent inquiry, or she accompanied the patients to the hospital?
Lordship, who? DW2.
Linda Gomes, yeah, DW2. Whether she conducted an independent inquiry to state that the three diseased individuals had significant pre-existing respiratory disease.
Yeah. She did not...
She had been taking care of these the people who died before the event took place, or she accompanied everyone to the hospital.
Lordship, understood.
Yeah.
Lordship, since I'm an honorable court, I have to be very true.
That is your witness, so you'll be
Yes.
in a good position to...
Not clear in the moot proposition, but there's what I could understand, she did it in the post-mortem, Lordship. Because even in the dead bodies, the post-mortems could also show so many things. Like she was involved with the post-mortem. Because toxicologists think even on a dead body, we can study the dead body and we could see what is there. If there's a previous respiratory existing diseases, it could be easily studied.
How come your witness goes to the post-mortem? It is your witness. No. Toxicologist is yours.
Lordship.
It's not a government one.
Lordship, absolutely correct, Lordship. Lordship, there's one primary thing is that in every witness, there's a thing called independent corroboration. Independent corroboration. Like every, especially medical or any kind of situation, there's this issue. There should be multiple, because she is also a toxicologist. She is also somebody who is equipped medically, talent-wise, skill-wise, the city
So
hospital.
you are not clear about your own witness.
No, we are clear about it. I'm coming. There are two arguments to it. So first thing is, Lordship, it's partly because of independent corroboration, because we are not denying that people died, but we also wanted to know to what degree of aggravation are we in any way involved in this. To what degree? Because at sometimes methane is us, we are accepted. But we are also saying that we are also in connect these things in PPP model, public-private partnership with the state, Article 12, like we have the TDA, there's also there. But we also want the independent inquiry. We also want to know what are the possibilities. The question is, when two differing views are coming, it should have been properly taken into consideration. We feel like in the lower court judgment, we feel, we argue rather, there's a judicial, there's an inapplication of the judicial mind, because the toxicologist is saying pre-existing respiratory disease exists, but they are saying that it's all about, here also it's debatable, but then here they say it's methane combustion because this incident itself has done it. It's also to see how to what degree who is talking. So these witnesses are not completely clear, the submission that comes from prosecution, which is why again I also took the PW2, going back to my original, to which we came to this, got into this argument. Rajesh Kumar, because Rajesh Kumar's son died, but in what circumstances? Did he die immediately with the situation that he couldn't be given even a medical treatment? Or was there a possibility he could be given a medical treatment and he went through the process? Because immediate death means a very serious aggravation. There's no chances of him to be alive, to survive this situation. And then another is like, there was some problem, but he probably given proper medication in time, he could have survived. Then the question also comes in other parties' involvement, who took him to the hospital, the how quickly, reflexively the doctor engaged with the patient who was brought into the hospital. So many questions comes into play, many parties got involved into play. So in a precise attempt to understand and to acknowledge the precise endeavor of law, I was attempting to look at all the witnesses clearly, and every time I look, I do see doubts. Basically, the doubts are, we are not the only one responsible. This is a systemic thing. So every time we look at the witness, it brings up many parties into the whole process. Again, now if I go to Lordship again, I have already engaged with Sunita Rao, ex-employee, which I've already established that how this witness is very important for the case, because she is a primary anchor to connect the CEO and his role and his directing will. And I have clearly submitted that there is clarity from the very reading of Miss Sunita's submission under an affidavit under the Honorable Court, as a prosecution witness, that she is making multiple arguments. There's a high possibility to doubt her having an vexatious interest. There's a high possibility of her making up things. I'm not saying she did, but there's a possibility she might have. So that thing also had to be taken into cognizance. And there was no independent corroboration of whatever she said. She said and it was accepted. So that part is also something that is important, Your Lordship. Going ahead to PW5, again, Arjun Verma, inspector. Of course, there also remains some lacunae in investigating officer. Now, he makes right argument. It's true. There's a sheer, page number 7 of the Moot proposition. There is sheer systemic failure. But however, what we see is that there is like a bit of limitations from his acts. Like, for example, he couldn't secure the area. Like, once the disaster happened, he should have done some, from his end, investigating officer. Since he got the FIR, he was also one of the first responders from the police side. He should have, before making all these sampling collections, which was done 40 hours later, let's say it couldn't be arranged immediately, understandable. But for the 40-hour duration, the area should have been secured by the investigating officer. So there remains lacunae from his attempts, which also have somehow tarnished the pure, the sampling, the purity and properness of the sampling to make this case, to make a proper argument to draw a tight circumstantial chain. Your Lordship, now I head ahead to the deposition of the defense witnesses. Now, Your Lordship, during the examination, again, here it becomes very important, Mr. Akash Mehra, who happens to be the director, and he clearly argues, Your Lordship, his submission as a witness, as a deposition, the director of the company has asserted that he will not be individually liable for the said offense, as a company being a juristic person is different from the individual comprising the company. This is also our submission. It's also something we stand by, this deposition. This is something very integral to take into cognizance. This defense witness, which we feel in some sense was not properly taken by the lower court, we feel there should have been proper focus on this submission.
So
on
categorically, you want that this court should take into consideration the statement given by Mr. Akash Verma.
Yes.
And therefore, I have put these questions to you to kindly narrate legally I'm reading his statement again before you.
Yes.
During the examination in chief, the director of the company has asserted that he will not be individually, means what? Collectively, he can be held responsible.
May I?
Learned counsel, can he be held collectively responsible? Number one, for the said offense as the company being a juristic person. Being a juristic person, does it mean that means for all the criminal activity, the company cannot be held responsible?
No.
No. So, now you cannot.
Thank you. I can argue. It clearly depends on the precise nature of the case, the circumstances involved, and the context of the case, Lordship.
I am only considering about his statement. Please make your argument on the statement given by your defense.
So, Lordship, yes, collectively, the state, the society, the system, collectively, possibly, would be held, may be responsible. However, the company on its own or any personnel of the company on its own cannot be held responsible for a systemic structural failure where the state equally remains complicit.
I agree that collectively he can be held responsible.
Along with the state, given that it could be proven.
Collectively he can be held responsible.
Along with the state, yes, given that it could be proven that he is in some way his directive will is responsible. Given that there is no other ancillary things involved motivating or changing the controlling the directions.
Collectively he can be responsible.
Along with the society, yes, we are part of society, Lordship. Collectively, we all are responsible for whatever happens in the society.
Now, you have to know, circumvent yourself within the ethics, right? That when something is happening, you cannot hold the entire society responsible for it.
Absolutely.
Mind well, it is the question of 62 persons who have been injured and 3 who have lost their lives. And be sensible when you are making the arguments. Here the question is again I'm placing before you, referring to your own witness, can he be held individually responsible or collectively responsible? Because you said that means you're going with your defense witness.
Individually, he cannot, just like our CEO also cannot. But collectively, with the state, collectively with the entirety of everybody involved, if found guilty, we could be held responsible. But we have to be found guilty for being involved. There should be possibility to prove mens rea. There should be possibility of us being directly, proximately involved, and given that, maybe. But if that chain, again, circumstantial, there is, like, it has been proven beyond reasonable doubt that we are responsible. But if there emerges doubt, there emerges third-party roles. These are general differences again, Lordship. Act of strangers are involved. Then,
If suppose this court will allow you or give an opportunity to you to ask your defense witness to change his statement, would you prefer to make changes?
defense statement. I believe that
Because he has not stated that things along with the other. If opportunity will be given to you to ask your defense witness to make or to correct his own statement, would you like to have it?
if given the opportunity, I would definitely like to have a conversation. It's not like I would want him to change, because if I am, then I'm asking him to go
And
for.
suppose if he's changing his statement,
Then he's doing perjury. If he's changing then it means he lied in front of the court. Then it becomes more clear there are more intentions in his mind, apart from achieving justice or apart from achieving true to the court. How much time do I?
Court.
Can I ask the
No. The question that being put the fact is that if court allows,
Yeah.
what changes you'd like to make?
On-
The court allows, no perjury involved. When the court allows,
Absolutely.
yeah, then there is no perjury.
he's making some changes.
The court allow.
Yes. Without bring
The
the
defense witness.
yes. What changes you'd like to make?
I would like to. I would suggest my client, I would suggest my deposition of the defense witness.
Yes.
What changes I would.
Yes, Akash Mehra.
Lordship, first of all, the thing is, like, if I say what changes, then I would have to say something that is something protected by.
You are protected. No perjury. You are protected.
Lawyer and client relationship. If I ask him to change something, there is a high possibility I'd be questioned that why specifically you asked him to change this part.
Therefore, I'm asking you, when he has made a statement, why you are adding something which he has not added?
I haven't added anything. But if maybe, Lordship, I'll be truthful in this regard, since I'm in front of the apex court. If I was there with Akash Mehra, and if I was allowed to give him proper suggestions to how to make this statement, which is something allowed as a lawyer, I could suggest and advise him, not asking him to make a statement. I probably would have advised him, and that advice might would have led to frame this sentence in a bit different manner, probably, if there was given enough time. But if I was given, and the court allows me, Akash Mehra agrees, and we were given a private space, and I've been asked that how better way he could frame himself to make a deposition, I might have given him a counsel in his best interest, which might have made him give a deposition which would keep him in a better position to which he is now, based on his deposition as a defense witness.
And proven that you are found guilty. To that extent, you're found guilty collectively. The state and your company is responsible, right? All can be sent to jail. Now, proven the fact that if I come to that, this your negligence part. Again, I'm repeatedly telling you, the tankers, trespassers, you are found guilty on that point. You cannot avoid that point. You're already found guilty for negligence. That is your guilt part.
Lordship, first of all, I would like to say one thing.
Maybe you have to pierce your corporate veil and then.
Right. So, Lordship, that's a very circumstantial question. First of all, we would have then asked, we have every right to seek legal immunity, or we have every right to ask corporate bail.
Admit that you are found guilty on part of that you are negligent.
No, I haven't. Your Lordship, the question was framed that proven we were guilty.
You're proven already. Your negligence part you have proven. You're not informing to anyone. Like as I have said earlier, the government has filed a case against you, and then you did not do anything against the government, and you were sitting idle, sitting silent on the part of the trespassers, tankers. That is your negligence part.
We have taken actions, Lordship. I never.
What action you have taken?
CCTV, Lordship. Part
CCTV you have it's gone. No CCTV.
No, CCTV is there. CCTV is only not there for 4 hours because of current failure.
Incidental or coincidentally, the CCTVs are out of action.
So
what is your action?
No, Lordship, the CCTV was my humble submission. The CCTV is a 24/7 situation, Lordship. The only reason the CCTV goes off if somebody comes and damages the CCTV or the current failure, collectively current failure. Like
there is no inquiry on your part also why the CCTV has gone off.
Yes, I'm coming to that. Lordship, no, it's not about inquiry. This is exactly where the very specific circumstance of the case becomes important. At very time, there's a geographical situation, climatic situation, a climatic situation that was also happening during this, it is in the Moot proposition. A climatic situation is also there, under which we are calling the force majeure. And it is something this is not a natural course of event. Lordship, this is something unnatural. And we are not the only one with a circumstantial, something new that happened. And may I humbly redirect the attention of the court to the very Moot proposition, Your Lordship, where we talk about, just in the middle, Lordship, we talk about force majeure clause A, and talk about, there's a meteorological report, Lordship. On December 14, 2025, a meteorological report has been published in a popular daily newspaper showing an unprecedented thermal inversion in Tripura. Thermal inversion. So there has been a climatic problem, climatic situation. Very much possible this situation, just like
climatic situation has put your CCTV out of action.
No.
Except every other thing.
Absolutely not, Your Lordship. Climatic condition have created some meteorological problem that might have led to the failure of the current department. There is a problem, something that the electricity board has to tackle.
See, unless there is specific evidence on that cannot be taken cognizance of by the court. This newspaper report
Lordship,
will not be of
Lordship,
any
this is
effect.
the most interesting part, Lordship. If I stick to the Moot proposition, nobody has an exact amount of evidence to hold anybody exactly responsible. Neither the the state would have respondents would have a case on it. But I'm humbly submitting, Lordship, that in regards to negligence, we have already been doing and done what we could do. We installed a CCTV camera, and we are saying to our submission, we are trying to get rid of this trespasser situation as of now. We are the one there, and also to take into cognizance, Lordship, the monitoring part is also something the responsibility of TDA along with us. And we are trying. We have people on the ground. We have people looking at the camera. But the current has failed. And it's not every day it happens, Lordship. Just one day. And this is also something in news report. It's the geography is not, the climatic conditions, the meteorology is not in our control. What I'm saying is like current failure, like flood, flash floods happens in places like city of Guwahati. Sometimes the current goes off. Like that thermal inversion happened. Some thunderstruck could have happened, and that could lead to the electricity failure. And electricity failure for 4 hours is very possible. It is not impossible. So the fact is here, Lordship, the circumstances of case is such, Your Lordship, that we could not be held responsible for the 4-hour absence of the current, which led to the 4-hour absence of surveillance camera. The surveillance camera itself is the proof, is our attempt, our heartful, willful attempt to secure the perimeters and have 24/7 visual eyes so that nobody could just trespass. And we have clearly said trespass. It means we are calling it illegal, Lordship. We could have said we don't know what happened. No, Lordship, our submission is that unknown tankers have trespassed. So when you say we also illegally trespassing, so this is something.
Yes, you rightly you have pointed out. For how many days this trespass was happening?
Lordship, it's not a continuous affair, Lordship.
2 days, 3 days, 4 days.
Not, Lordship, as we could understand from the facts of the case, Lordship, it was sometimes very random. Like we saw illegal. It's not a continuous of every day. Randomly, at sometimes something happened, and we are trying to catch them. Yeah.
So apart from these 4 hours of CCTV camera,
Yeah.
other days it can be seen that who are the trespassers. Or before the lower court, have you submitted any FIR lodged against the trespasser? It was not submitted.
No.
So there was a negligence on your part, not taking due course of action against the trespasser, and because of which the life of so many people have been put on a stake.
Much obliged, Lordship, may I please humbly just come and argue or rather disagree on the last part of the statement. Maybe in a very different circumstances, Your Lordship is arguing maybe there could have been a minor gross negligence, not at all. The issue clearly talks about criminal liability, not at all. Minor negligence, probably, I am not sure about it. But Your Lordship, I am very sure that is not the specific reason or proximate or directive will of the situation that led to this disaster. There was the lack of active role in terms of segregation that has been done by the TDA. There was mistakes and negligence from other parties involved. There was this meteorological situation. This is basically colloquially also referred to as act of God, which is also somehow legally from a contractual point of view. In the PPP, we are already protected by force majeure clause. Basically, we are not responsible for unforeseen activities. So what I am submitting here, Lordship, that your Lordship's doubt, your Lordship's query or seeking the clarity from my end is absolutely correct. But am I absolutely responsible? No. This is a purely circumstantial, and a lot of people are involved in this circumstantial, Lordship.
Okay, I am a little bit pinpointing.
Absolutely.
In the said case, the criminal court convicted the CEO, namely Vikram Sheth of Green Horizon Developers, with criminal punishment for the alleged offences and also for their failure to statutory compliance of waste management and awarded a nominal compensation to the victims. Now, being aggrieved with the decision, etc. So there are two parts. Vikram Sheth convicted and criminally punished. So if this court accepts that we know that for criminal punishment, the guilt has to be prosecution. It's the prosecution's duty to prove the guilt beyond all reasonable shadow of doubt. The accused doesn't have any responsibility. But so this part, if we say that okay, maybe there is some laches. What about the other parts? My other two co-judges have time and again mentioned
Nominal
that
compensation.
negligence of the company is proved. So, are you going to accept that imposition of nominal compensation was okay?
Yeah. Lordship, our client is fine with compensation, but or any kind of rather the wordings, we are happy to give financial benefit or aid, but we would not accept the word compensation because that would mean we have done something wrong. Basically, this is a more like a punitive damage that we are paying. Here, Lordship, we have clear we are more than happy, willing to do a corporate social responsibility because true, we are living in a vicinity, in a society, we have public
No,
duty.
but see, the point is,
Yeah.
to fasten the liability of Bikram Sheth,
Yes.
everything has to be very clearly established to send him to jail.
Yes.
That is one thing.
Yes.
But the other part, my co-judges has repeatedly pointed out that there was negligence on the part of the company. So on that point, what you have to say? They have pointed out you did not, if the trespassing was there, you did not lodge any complaint. Then other things, you did not, what you did if there was 48 hours of gas, all these things. So some indications of latches on your part was there.
Lordship, if we really have to push, and as part of a society, something has to be taken into cognizance, then perhaps at the least, or perhaps at the maximum, it was a mistake, not negligence.
And mistake led to death of some people.
No. It was a
And you are not ready to compensate.
we are ready to aid, not compensate. We are ready to pay money
To aid or apply your theory of CSR,
Yes.
you need to have a medical unit for this. Which you don't have.
Lordship.
To apply your theory of CSR,
Yeah.
you need to have your medical unit. You cannot individually go and help someone like this.
Yeah.
You need to have a medical unit for this to apply your concept of CSR. So helping and aiding through CSR will come that way, but compensation is when you are found guilty, and you cannot do this kind of CSR. You cannot do CSR like this.
That is the thing, Lordship. We are not acknowledging that because in the current case, Lordship, we have been made to the lower court criminally liable. This is a case, as it said, it's a criminal punishment. We are against this because, Lordship, my client is not just a responsible citizen, but is also a dignified citizen and is running an honorable company. So we are not just innocent until proven guilty, but we are also arguing that this language of the judgment that comes from the lower court makes us visibly criminal, makes us pay nominal compensation to the victim, which is okay. We want to pay aid people who are victimized by the structure to which we equally are victim. Here, Green Horizon is equally a victim of a structural systemic problem where the state has unable to provide him the necessary funds, where the duties of segregation that has been done by TDA, they haven't done it. We are
As an
equally victim.
as an advocate, you are very well assisting this court, but you are an officer in the court when you are an advocate. So you are assisting the court very well. But my view on the part of negligence, I'm not convinced yet. So it's like as if you are arguing to save your company and not to assist the court.
Much obliged, Lordship. Lordship, as a humble, diligent student of law, my priority always remains to assist the court. And along with it, also assist in arriving justice collectively, and that includes my client and also to the parties involved. So, in collectively, I see as a team, the advocate, the side counsel, the side defense, the jury, the bench, including the court masters, we all are a team collectively approaching justice through our little meager contributions. So I am definitely with my client, but I am not just only with my client. I'm also with the law. I'm also with justice, and which is why, Lordship, we are ready, as I rightly say, in the negligence department, Lordship. Partly, we also have to then establish. They have to clearly establish that, or I have to accept in what regards I have been negligent, Lordship. I would have been negligent if I wouldn't have done anything to stop what has been happening. It is in my control. But the moment I install CCTV, the moment I've been trying to catch the people who are creating trouble, the moment, again, very important, Lordship, very important, even going back to the annexure, your Lordship, when PW5 went, after the FIR, he went to the office to collect the logbook, They also found that during the raid, it was found that several notices sent by Green Horizon of the Municipal Corporation requesting funds for composting unit repairs, which remains unanswered for a year. So, Lordship, if we had, we are also asking more money from the state, and I argue further, it's not just about unit repairs; it's also about to have even more securities. Like we are undermanned, undercapitalized, and we are struggling equally for a structural fallacy that has been created by the state. If we would have given more assistance by the state, we would have done much more to what we have been doing. We are reduced to CCTV cameras. We could have easily positioned 50 more security guards if we would have received some assistance from the state or the TDA. So partly it is not negligence. We are doing everything we can, Your Lordship. The CCTV is the proof. The fact that, Lordship, the entirety of this case starts from the month of, our activity starts from June 1, 2025. And until here, as the case goes, it's now in December. In this entirety of the time, Lordship, our only failure was not having surveillance for
You
4
did
hours.
not press for security guards.
Lordship?
As you said,
Yeah. I said 50 security guards. Like more people, man them more, not just devices. We have security guards, but it's also a big compound. Securities has also moved. There are blind sites. We have less funds. What we are saying, Lordship, the entire duration from where we started operating into that, into this case situation where we are standing now, if we could be pointed out as negligent, the time frame would be 4 hours. The question is the, if I have to say mistake, is the mistake of 4 hours so big and so huge that we should be considered negligent to the point of gross negligence, to the point that we would be held criminally liable, and this entirety of the disaster would be pinned on us because 4 hours couldn't be cornered? That is a huge responsibility that has been pushed only on my client and to this company. Then the question comes, Your Lordship, is it reasonable? Because it appears, humbly, Lordship, I would say, it appears a little unreasonable. It appears a little more strong, aggravated cornering against one specific party while conveniently not looking at the all other parties involved. Our mistake at best was not knowing that there would be a current failure, not able to see that there was a force majeure. Our mistake was not being able to see something that perhaps nobody could see. As Lordship, it is colloquially said, force majeure is actually activated on act of God. And then what is the colloquial wording of act of God remains, because probably only God could have known how to avoid this 4-hour mistake, if there was a mistake. But for being man, human beings, 4-hour mistake, even if it was, even it is too less, Your Lordship. I would humbly submit that 4-hour mistake is very less. For the entire time we were there, we are security, we are already doing how much more? So, Lordship, if Your Lordship is satisfied with the majority of my submission, may I kindly summarize the entirety of my submission? And also, Your Lordship, if Your Lordship, since we have the availability of time, if Your Lordship wants to clarify any questions from even the previous council's issue 1 or 2. Lordship, as a responsible, as my attempt to be a responsible advocate, I would rather request to summarize this debate quickly and give the side defense respondent a chance, thereby save the precious time of the court, Your Lordship, if that is allowed. Much obliged, Your Lordship. Huh? So, Lordship, I think I have still 10 more minutes. So my request is, I am more than happy to take the entirety of it and go through the grilling process of the sequences. But if Your Lordship allows, I'd also like to give some time to my co-counsels to save the precious amount of the time. And would I be taken any wrong? I would rather choose to summarize, since I have met, and give the opportunity to the side counsels. Much obliged, Your Lordship. Your Lordship, so largely I have engaged with the issue 2 and issue 3 and issue 4, and my co-counsel has addressed issue 1 and 2. And Lordship, we have collectively tried here to clearly indicate a very argument that here the log, in regards to my issue, Lordship, the log B, the logbook, the tempered CCTV footage, all these things, the requirements are not strong enough. The case is not strong enough to hold us criminally liable or even to consider us to be negligent, Your Lordship. At best, it was an unforeseen situation that for the entirety of our time, we couldn't, from June, our operation started beginning in June to until the December. This incident happened, to which we are very sorry, and we also feel bad that so many, and empathetic to the situation, what has emerged and what all these families had to go through. But what we see as our limitation was not to able to foresee, and we are also apologetic about it, the 4 hours that we couldn't really see, because if we could have tapped that very limitation of 4 hours, we could have probably even caught the culprit. We were of the strong opinion, and we do feel apologetic for it, that the current failure happened and we couldn't come up with some solution to that. And largely in regards to the issue 4, Your Lordship, I would humbly like to summarize that the CEO Vikram said doesn't seem to be here to be vicariously liable for the depth and the entirety of the event in the principles of alter ego, because this failure was systemic and institutional, for which only the company as a juristic person, let's say this question, can it be liable? If we do not see it to be liable, we rather see the system as a whole perhaps could be liable, that we need more disaster. In this regard, I would say, Lordship, probably the state as a collective and society as a collective, we need to be more prepared for unforeseen circumstances and situations of act of God. So we need to be more clear on disaster relief plans. And we believe this is where we could do as a company more on this thing, to make sure that this event that happened, for this limitation on our part of not being able to gauge the limitation of 4 hours, is where we feel empathetic and we feel we could do more. And if Your Lordship is satisfied with the summary and the entire submission, I would like to submit my prayer, Your Lordship. Much obliged, Your Lordship. Wherefore, in the light of the complex issues raised, the detailed arguments advanced, the myriad of constitutional statutory authorities cited, and the pleadings made, it is most respectfully prayed before this Honorable High Court of Tripura that it may be pleased to allow the present criminal appeal and quash the conviction and sentences imposed upon the appellant Mr. Vikram Seth and Green Horizon developers under Section 105, 270, 280, and 287 of BDNA 2023. Hold that the exclusive criminal liability imposed upon the alleged is legally unsustainable, given that the Tripura Development Authority materially contributed to the offences through statutory omissions. Declare the electronic evidence, logbook B and CCTV footage, and the delayed forensic samples as legally admissible or devoid of evidentiary weight due to statutory non-compliance with Section 63 of the BSA and a fatal break in the chain of custody. Hold that the CEO, Mr. Vikram Seth, cannot be held vicariously liable for the institutional or systemic failure of the company under a reverse application of the alter ego doctrine. Pass any other order, direction, or equitable relief that this honorable court may deem fit and proper in the interest of justice, equity, and good conscience. For this act of kindness, the appellant, as in duty bound, shall ever pray.
We would like a recess of 2 minutes to attend to the restroom. If it may please the council, if it may please the bench, the council would like to request a recess of 2 minutes to attend to the washroom. Much obliged. Greetings to the bench. The council appearing on behalf of the state of Tripura is in the case of the Vikram Seth and Green and Horizon Development versus the state of Tripura. The council would seek the permission to refer the bench collectively as your lordship. If your lordship is well aware with the factual matrix of the case and the statement jurisdiction, the council would like to proceed with the issues at hand. The current council will be dealing with issue 1 and issue 3 of the moot proposition, and the subsequent co-council will be dealing with issue 2 and issue 4. If your lordship may permit, the council would like to proceed by giving provisions, statute and rules and the compendium. Yeah. Much obliged. Your lordship issues 2 states whether the act of the accused satisfy the ingredients of culpable homicide under section 105 of BDNA, hereby BNS. This, your lordship, this respondent submission on issue 1 will proceed in a fourfold manner, and it will go with the first strand that the statutory ingredients for section 105 of BNS are satisfied. Your lordship, section 105 of BNS penalizes the cause of death in 3 alternative ways. Firstly, the act done by the intention of causing death. Secondly, the intention of causing death with bodily injury as is likely to cause death. Thirdly, and any knowledge of the act that is likely to cause death. The third limb precisely is what the council will be taking up, since this is the word likely has been defined in Andhra Pradesh versus Rayavar Punaya, where it was meant that likely means to connote a real or substantial probability of death, not a remote possibility, but a genuine foreseeable risk of death arising from the very nature of conduct. The council would like to respond to Honorable Learned Council petitioner that they falsely mentioned that this culpable homicide not amounting to murder fell under section 100 of BNS. However, what the present issue argues is the culpable homicide not amounting to murder. In the present case, there were 3 deaths caused due to the failure of Green Horizon Development, hereby referred as GHD. And to prove that, the council will further elaborate that there was knowledge that was personally traceable to the CEO of Green Horizon Development. Firstly, Dr. Ananya Sharma, an expert from CPCB, a very renowned board, centrally renowned board, and she found that the company's composting unit was not functional for at least 6 months prior to the fire. Where biodegradable waste is not compost, it generates methane, and it was the methane which was the reason for which this the thermal immersion further escalated and turned into a fire, which led to the death of the 3 people. Further, your lordship, the basic rules of waste management under Rule 7B of Solid Waste Management Rule states that the company shall ensure no harm to human health or environment, who allows the composting unit to remain broken for 6 years for 6 consecutive months cannot claim ignorance of such consequences. Your lordship, during this course of 6 months, methane was constantly mixed with all other inseparable degradable waste and all other types of industrial chemicals as well. Your lordship, further, the prosecution witness 3, Ms. Sunita Rao, was a quality control manager at the same company beforehand. She gave direct first-hand testimony that CEO personally ordered the halt of waste segregation and stated that to speed up the disposal. And this was his verbatim expression that regulations are just paperwork. Therefore, it established that behind all the scenes, he knew that these regulations would never affect him if there are no investigations upon him. Furthermore, the prosecution witness 5, Inspector Verma, found
Prosecution witness 2 is not reliable to my view. On the night of fire, air became thick and yellow. At night, I can see thick the air. I can see the thickness of air, and the air became yellow. At night, I can see that. Can I see?
Indeed, Your Lordship.
That's not reliable. You're basing your facts on that, arguments on that.
Your Lordship, I have mentioned that prosecution witness 3, Sunita Rao.
Oh, you said three. Okay. PWI was on P2. Sorry for that. Yeah. You can carry on. Yeah. You directly, we are aware of the facts. You can directly come to the point of issue number 1 on your supervisory and monitoring.
Pardon?
You can directly come to your issue number 1 on your supervisory and monitoring part of yours. You can directly come to that point. The facts we are well aware of. Petitioner has already explained about the facts.
Your Lordship, I would like to say that these monitoring aspects that we are talking about in the current situation, it is alleged by the council that the GHD in fact did not follow any of these monitoring situation, because they are clearly stating that there was a third party involvement within their boundaries. And GHD was the one who was given in the private-public partnership, given the responsibility to segregate biodegradable waste as well as to manage the site. The Tripura Development Authority was responsible for providing just the primary segregation infrastructure at every municipal ward before the waste reaches to the final land site. Further, Your Lordship, it was held that this GHD shall also abide by the solid waste management rules, and it was clearly mentioned before that solid waste management rules were further degraded, and
State is responsible for monitoring as well, hazardous waste monitoring.
the state is responsible. Indeed, Your Lordship, the state is responsible for supervision of the GHD's work.
Yes.
GHD's work. However, its supervision is only limited to the hazardous substances that are found within this landfill site.
So larger duty is cast on you. With the monitoring and supervision, the larger duty is cast on you.
Your Lordship, although the liability upon the state is of the supervision, however, the state shall not be liable for any of the individuals act that are against the contractual relationship between both the entities. Firstly, under the contract, it was held that the company would only segregate biodegradable waste and ensure scientific composting. However, composting was stopped by Green Horizon Development, as told by prosecution witness that there were at least 6 months since the composting was stopped, and there was also proof that segregated biodegradable waste was not found during the site on the site. And also there was no segregated biodegradable waste found after the research was conducted, after the incident occurred. Further, the Rule 2 of Slum Rule 2026 states that the rule does not cover industrial waste or hazardous waste, hazardous chemical, biomedical waste, e-waste, battery waste, and radioactive waste that are covered under separate rules framed under the Environmental Protection Act. And it was also held that the company shall also abide by the Environmental Protection Act as mentioned in the Moot proposition. Shall I proceed with my issue?
Yes.
Your Lordship, further, I would like to also contend that more than just knowledge, the thermal inversion that also was not novus actus intervenens, because the legal test for novus actus intervenens states that this is an intervening act that is of a higher threshold compared to what the current situation is. And the reason why the blast occurred was firstly because the methane was spread out, not only in the management site, along the outskirts as well, because this led to this smell and eventually all that foamed air, and also it also seeped underground, and thereby it also swept along the river bodies, and thereby affecting 3 districts. And also this violated the Wetland Act, because the land also qualifies as wetland because there is presence of Yamuna B rejuvenation zone, a state protected wetland area. Therefore, Wetland Act was also violated in this. Further, Rule 45. Further, under the Wetland Act and Rules 2017, Rule 45, specifically D and E, enacted under environment, state that activities causing pollution, solid waste dumping, and untreated effluent charges in or near notified wetland and zones are expressly prohibited. In this case, as I mentioned before, all the methane chemicals, the dirty chemicals which were affecting the nature, crept into the soil and thereby flown into all the river bodies. Proceeding, there was also a foreseeability which could have stopped the disaster. There was also a foreseeability that the GHD could have stopped the disaster because in the morning itself the newspaper agency had spread that there are chances of an unprecedented thermal inversion that might come. Your Lordship, it is mentioned in the Moot proposition.
States should be more alert on that point because there's a thermal inversion is coming up. So states should be more alert on that point when there is a thermal inversion is coming up, because you were monitoring that also, that too, the environmental department, if I call it, the meteorological department, you were heading it, we are taking care of it. So state is responsible and should have taken precautions in that regard. Company is not responsible for that.
Your Lordship, indeed, Your Lordship, the state fulfilled its duty as meteorological report had been published in the daily newspapers showing an unprecedented thermal invasion in Tripura.
Did not take any precaution.
The precaution were taken as in the spreading the news in the public. However, as for the particulars of the GHD, it was the ignorance of the GHD that they did not perform their duty with reasonable care. If I may proceed with this.
Yes.
On this point, I do have one things to understand.
Indeed.
The TDA claimed that their primary segregation infrastructure was under renovation.
Indeed, Your Lordship.
This was there.
Indeed, Your Lordship, it is mentioned that their primary segregation infrastructure was under renovation. Therefore, they could not provide with proper mechanisms to further help
Means
GHD.
that the mixed waste has been dumped in the landfill, right? So it means that you are also contributing to the cause which has occurred.
Your Lordship, I would like to also elaborate the duties of the GHD company. That their role was specifically to segregate the waste that was coming to them, and the duty of the state was to provide them with all the necessary infrastructure at every municipality ward before the waste reaches the landfill site. Once it reaches the landfill site, it is the duty of GHD.
Understood.
Indeed.
Have we provided the mixed waste over there? This is my
Indeed, Your Lordship, due to the renovation process.
whether you were under the responsibility to segregate those waste and to provide an infrastructure which was under renovation.
Your Lordship, the state was under the obligation to provide the infrastructure. There was a mishap due to the renovation that they were not able to provide. However, this public-private partnership.
Have you disclosed this fact before the lower court that you have intimated the company that mixed waste was provided at the landfill?
It was disclosed during the internal audit that TDA had delivered the mixed waste to the landfill site for months.
These are the internal. What is the status of this internal audit? Who has done it? Was it the internal audit of the TDA or the company?
Company.
So the company, they have done their best part. What about your responsibility? Have you fulfilled this responsibility? Because of your failure, can you claim that means we are not responsible?
Your Lordship, it is indeed Your Lordship. However, when the ID officers visited the site weekly, the signatures were all clear logs for the November of 2025. That means that
you are talking about the December.
Your Lordship, we are currently on the date of 14 December, before the incident occurred. The last check that was done by the ID officers regarding the waste management, waste collection, and every process followed, it was all clear on the logs. So, following this point, the Moot proposition has been gray whether the state has followed its duty beforehand, or is it just now that the renovation has started to occur and therefore this internal audit surfaced? And Your Lordship, if I may just have a minute with my researcher regarding the issue and just elaborate you more with the facts, if you may.
Yes, yes.
Much obliged.
Time will be counted.
If I may, Your Lordship. Your Lordship, if I begin with the prosecution witness 3's statement, it is clearly said that Vikram, the CEO of GHD, has said that all these claims that the regulations are just paperwork. The TDA officers are not on their part liable for this fault. It is for Vikram. It is the profit of Vikram. Suppose the waste comes and he does not segregates them. It is he's saving the operational cost, and thereby. Indeed, Your Lordship.
On your own statement, what you have stated, you are on the point of that the signature of are on all clear logs.
All clear logs.
Number 25.
Indeed, Your Lordship.
After that, what will something statement?
Indeed, Your Lordship. I was after the discussion with my researcher, I have mentioned that after there were all clear logs about this ID inspector that whatever the state supplied, they were all clear about the ingredients that came in. There was no hazardous waste contained in it. And further, this statement that regulations are just for paperwork, and to stop it was said by Vikram said that Vikram said order us to stop the segregation process to speed up waste disposal. This would save him operational cost, and this was rendered. It was further written in the observation by the IO. Pardon, Your Lordship, by this statement by Vikram said was written in prosecution witness 3 by Ms. Sunita Rao. And further, in the charge sheet of the brief observation, it was written that these investigations revealed that the accused, Vikram Seth, deliberately bypassed segregation protocol to save operational costs. Thereby even strengthening our claim that from the state side, although they were not the specialized authority, they were not scientists who could guarantee what percentage of waste is hazardous, what percentage of not. However, these logs that are clearly mentioned that from their side, the waste that was being sent to them was 100% clear.
My question is whether you have provided collective waste. This is the only answer.
Collective waste, Your Lordship, collective waste as in the biodegradable waste or the biodegradable waste mixed with industry chemicals?
That is also not a question. The question is that when your, the infrastructure was under renovation, have you taken any measures to segregate those waste, or you have supplied the entire mixture over there?
It was the duty of state to supply the waste, and it was later on the duty of state. Yes, indeed, Your Honor, mixed.
Yes. This was the only thing.
Much obliged. Shall I proceed with my arguments further? Much obliged. Proceeding with the third sub-issue, the accused Vikram Seth has independent criminal liability and cannot hold the state liable under the public-private partnership framework. This is said because both the parties came under the public-private partnership framework under the contract that Vikram Seth would follow his obligation to fulfill, that he will segregate biodegradable waste, thereby and ensure scientific composting. And secondly, the state would provide
Company, not state. It's not written state. It's written the company has managed to segregate the biomass.
Yeah,
Don't
indeed, Your Lordship.
State. It was not written here in the fact.
The state has I was moving on to the next sentence, but pardon your lordship, I'll phrase it again. The company was responsible to fulfill their obligation that they will handle all the solid waste and they will segregate biodegradable waste and ensure scientific composting. Secondly, it was the state's duty to segregate primary segregation infrastructure shall be provided to them at every municipality. This was the primary consideration between their contract. However, now that there has been no scientific composting for more than 6 months, this was proven by Dr. Ananya Sharma, a learned scientist. These obligations have been violated. Therefore, the state is under no contractual obligation with the company now. And
Have you terminated those contractual terms?
Under Article 25, once these obligations have started to fall, it will come under the void contract, your lordship.
Accepting it, but for the void contracts also, have you given a notice? Because there was a enforceable agreement between both the parties. So if suppose someone has committed a breach, have you submitted any notice to him?
Indeed, your lordship, the state has not provided any particular notice.
So you have failed in performing your own, duties.
But the council would like to proceed further with their argument. Thus, after the particular reason why they were not sending any notice, because on the state side they were investing all the garbage that was being sent, all the biodegradable waste that was being sent. It was from their end, it was 100% of their obligation. However, it was later that they came to realize, after the incident, that they were doing this behind the back. They stopped composing, because Aditi Sharma's analysis came on 16th December and the incident occurred on 14th December. Their contract was going on from June and it was the last checked on November. So between that point, the contractual obligation was fulfilled. It was under the state's impression was that these contractual obligations are being fulfilled. However,
Council, the applicant have not made any argument that the contractual term was over, or there was some voidness is there. It is you are pleading. So you have to provide that when you are making claim that contract term comes to end because of the violation. Have you served any notice?
your lordship, this public-private partnership, that is, it was before that these notice could be served, that the state intervention had to come because of the incident that occurred. It was the notice the notice was not even served, because it was the public partnership was going on when this incident occurred. Indeed, yes, your lordship. If your lordship may, I would like to proceed with my issues. Under the fourth strand, the constitutional dimension, Article 21 states that Subhas Kumar versus State of Bihar held that the right to life under Article 21 of the Constitution includes right to enjoyment, pollution-free water and air. However, the three victims of that fire were their right to life was extinguished by the accused operation. Further, it was the principle of absolute liability was also held in MC Mehta versus Union of India, and an enterprise engaged in hazardous or inherently dangerous activity owes an absolute and non-deliverable duty to community to ensure no harm result from the activity. In this case, the biodegradable waste that was being sent, that was getting mixed with the industrial chemical. It was in the analysis of Aditi Sharma that said the pressure cooker effect that was being created was because the landfill contained of 40% of non-biodegradable industrial polymers. These industrial polymers were the chemicals that were mixed along with biodegradable waste and were not treated.
On the last line, I cannot definitely say.
Your Lordship, Ananya Sharma says that she cannot most definitely say that if methane alone caused the pressure cooker. However, she does not deny the allegation that methane is not a factor. Yeah, or if the illegal dumping of industrial waste by unknown third parties acted as primary catalyst. This illegal dumping of industrial waste is alleged by the company that it was within their. Ananya Sharma conveyed this narrative. This was the company's allegation. Indeed, Your Honor. What the council is trying to say is but what the council is trying to say, this Ananya Sharma is saying, expressing the narrative of the company, but this is not true. The state claims that this is not true, and the state and it is up to the liability of liability.
You are not accepting the statement given by your PW1.
We are accepting that
You are contradicting yourself.
Ananya Sharma, you said she stated that it is the narrative of the company. You stated that. What Ananya Sharma said, you did not declare her as a hostile.
Indeed, Your Lordship, yeah, I apologize for saying Ananya Sharma as not a witness. However, we are
No.
not
You said it is the narrative of the company. You said that.
this
You should have declared her as a hostile witness. You did not do that.
I would like to rephrase my statement, Your Lordship. This illegal dumping of industrial waste was a claim of this company. Ananya Sharma is saying that if it was due to this claim that they are arguing, it is still unknown who these third party were and were they primary catalysts in this. And the state shall, under the obligation, the state shall hold liable because it is ultimately the duty of the company to manage the site. If they are not,
State shall be held liable.
the state is alleging that the company shall be held liable due to the fact that it was their right, it was their duty to manage the site and to prevent any illegal trespassing or anything that they claim is happening. It was the state's duty to protect the area under which they were obliged under the public partnership.
No. Regarding this third party entry into the site, what I have to say is that you cannot shrug off your liability by putting it on the company because you are the state, and along with that the monitoring, you rule it. Meteorological department, you rule it. So you cannot shrug off a liability like that. It is that it is that the company should have informed you, but that equally your liability
You'll,
regarding the third party entry into the site.
shall I begin my
Yes.
Your Lordship, indeed, you are right. However, one thing that the state would like to mention that our liabilities were limited to segregation and hazardous waste. Our liabilities were not limited to the land site that was given to them to hold, to manage, to degrade all the waste and further compose them. This was
Rather, I will use the word monitoring. You have as a state, you have the capacity and everything. If I go by the rules, then you have the monitoring in entirety, the supervision. So your entire argument goes off with that monitoring and supervision, state.
Your Lordship, shall I begin my argument? Much obliged, Your Lordship. Your Lordship, the state, as before I mentioned again, the state was unaware of all the things that were happening. If I cite the Moot prop, it is written that the second last line, Green Horizon argues that they were only contracted for solid waste, but the industrial chemical found in landfill were dumped by unknown tankers who were illegally trespassing. This claim came after the incident had happened because it was mentioned before. The toxic fume that were released on 14 December led to hospitalization of 62 residents in the vicinity. This was the statement that Green Horizon released to escape their liability after this incident happened. The state was informed of the illegal trespassing after this happened, Your Lordship.
You don't have any liability for monitoring or supervision on that?
Your Lordship, in the contractual obligation, this liability was given to the company. The state did have monitoring liability, but beforehand, it is the responsibility of the company to ensure that these things not happen. And even if they happen, it is the duty of the company to report to the state that this is happening. The state was not reported beforehand that this has happened. It was only after this came into the news or whatever, wherever their statement was held, that the state got to know. Much obliged, Your Honor, Your Lordship.
So in the clause, it was mentioned that stating that the state would be responsible for hazardous waste monitoring along with the force majeure clause. It was very much part of the agreement. Yes. It was very much part of your PP agreement that the state has to monitor the hazardous waste. So if at all, suppose I am taking this, conditional statement, by making this conditional statement that there was a failure on the part of the company to segregate biodegradable and other waste, and there was a presence of industrial waste also. Was it not your responsibility to monitor and provide the presence of hazardous waste? Because of this hazardous waste, the incident has to.
And for that matter, enforcing the company to carry on the as per agreement, carry on their works.
Pardon, Your Lordship, I could not understand.
Yeah, so I think that even though there was the presence of hazardous waste on the landfill, which you were having the responsibility to monitor it, and at the last, in the month of the last, you are giving, a clear check on the logbook, saying that means all things are clear. Means that there was a presence of bribery, there was a presence of something illegal which is going on, to which you are also contributing to that.
Your Lordship, the council would like a recess of 1 minute with the researcher to discuss
The
about
board is having very less time, so please be very prepared. Okay?
most certainly. Much obliged.
Yes, this time will be counted. No, time will be counted because they are making the argument, and that argument, they are comparing us to time and again put cross question on the same things. So this time should be counted in the presentation.
Your Lordship, much obliged for the research that was. Your Lordship, the state would like to argue that these all clear checks I mentioned before, these were the all clear checks given by the staff of the IDA, and it was the discretion of Vikram State who put them.
What is the idea?
It was the TDA, Tripura Development Authority.
It
And-
works under whose control?
It works on the state. However, these were the employees of the state, and
Okay, so you agree with this fact?
indeed, Your Lordship.
You are also the instrumentality of the state, you are also the state.
The company is also indeed, Your Lordship.
Come, move ahead.
Your Lordship, if you are satisfied with the issue 1 at hand, the council would like to proceed with issue 3 at hand. Issue 3 states whether logbook B and the CCTV footage meet evidentiary requirements and whether the chain of custody was broken by the 48 hours delay. Your Lordship, the respondent humbly submit that issue 3 will be divided into 4 parts. Firstly, logbook B is a physical document and does not require a certificate under section 63, subclause 4 of the BSA. Secondly, any deficiency in section 63, subclause 4 of the BSA certificate for the CCTV footage does not warrant exclusion for both structural and doctrinal reasons. Thirdly, the 48-hour delay in sealing the site does not constitute a fatal break in the chain of custody. Fourthly, even setting aside all technical disputes about individual pieces of evidence, the totality of prosecution case established guilt beyond reasonable limit. Proceeding with the first sub-issue at hand, Your Lordship, there shall be distinction between the electronic record.
Second. Come on.
CCTV footage, Your Lordship. On the second sub-issue, the CCTV footage certified deficiency, the certificate deficiency does not warrant exclusion. This is because, Your Lordship, the CCTV footage was seized from the applet's company's own private facility. The recording system, the server, the networks, and it was all under the exclusive custody and the administrative control of the accused, that is Vikram Seth. Under section 63, subclause 4 of the BSA, it requires that certificate shall be signed by the person in charge of the computer or communication device. However, in case of Muksat Sheikh, Ghafoor Sheikh versus State of Maharashtra, it shall be referred in the compendium. Your Lordship, it is on page number 21, Your Lordship. The highlighted paragraph states that the benefit under section 436A of CPC has been intended to be given only to under trial prisoners. The word during the period of investigation, inquiry on trial, maximum period of imprisonment specified for the offence is significant. They indicate that only the person who has undergone detention for a period of 1.5 more of the maximum prescribed period punishment during the investigation, inquiry, or that under the code who is eligible for his release on personal bond, with or without sureties of bail as the case may be. The legislature was aware of the difference of the status of an under trial person, a convict, and with it of the consequences of the detaining a person who enjoys presumption of innocence till found guilty for unduly long time. Your Lordship, continuing what was the inference in the case, it is further said that the reason why in the section 63 subclause 4 of the BSA requires the certificate to be signed by the person in charge. However, it cannot be. It can, according to the this case, it is expected that the person to secure a certificate from an accused cannot be done who has lawful control of the device for two reasons. Mainly, the first accused will never agree to sign a certificate against themselves. And secondly, even if they sign, the criminal matter cannot be upheld in the court because it would give the self-incriminating evidence against themselves. The right against self-incrimination under Article 20 of the Constitution of Tripura creates a constitutional barrier to literal compliances with Section 63(4) of the Act. Further, in Arjun Pandit Rao Kotkar versus Kailash Kushan Rao Grontyal, it was held that the special sections shall be given more preference over standard sections. Therefore, it is the certification under the section 63 subclause 4 shall be mandatory before counting in any evidence as valid of electronic means. Further, there shall be authentication through alternative means. Even absence of a formal certificate, the authenticity of CCTV footage is established through alternative corroborative evidence. Under section 63 part 2 of the BSA, the data was generated in ordinary course of landfill's automated monitoring activities. Section 115 of BSA raises a presumption of official regularity in the performance of official act by public servant. The investigative officer's seizure and handling of the footage carries this presumption. Thirdly, the 4-hour gap is justified. Your Lordship, the 4-hour gap in CCTV timestamp does not taint the entire recording. It is because in Chandrabahan Sudam Sanap versus State of Maharashtra, it was held that a structural gap in digital evidence does not warrant mechanical exclusion. The court must evaluate whether the remaining portion is sufficient to give qualitative strength or not. Your Lordship, moving on with the part 3 at hand, the 48-hour delay did not break the chain of custody. Prosecution Witness 5, Inspector Arjun Verma, explicitly deposed that the chain of custody for soil and gas samples was strictly maintained as per statutory protocol. The statutory basis for investigative officer seizure power is under the section 185 and 106, where it was section 185 mentioned that it should be properly documented, and section 106 mentioned that there shall exist a seizure list under which all of this shall be written. Further, the legal standard for chain of custody is challenged. It was in Bharat Lal Ambale versus State of Chandigarh that it was held explicitly that technical or procedural gap do not automatically violate a trial or mandate acquittal. Your Lordship, the court must evaluate the prosecutions holistically assessing whether the overall chain of custody has been established as corroborated with credible sources of oral testimony and scientific findings. There is a critical distinction between the appellant's collapse that a delay in sealing the broader crime scene is not the same as break in the chain of custody for specific individually packaged and witnessed scientific specimens. The FSL report that confirms high concentration methane and toxic leakage is an independently verifiable scientific finding, and the forensic science laboratory is a credible source for that. Its value cannot be undermined by attacking the timing of the perimeter sealing. Furthermore, the totality of evidence established guilt beyond the reasonable doubt. Firstly, in response to the learned opposing counsel's query, the position of responsibility holded by Aditi Sharma is of a very high degree. She belongs to CPCB, that is one of the
Ananya Sharma, right?
prosecution witness one.
Yeah, Ananya Sharma. Yeah. Okay.
She holds the position as an environmental scientist under CPCB. CPCB is the central board, a state authority that defines the pollution standards of India as well, Indica as well. Further, Your Lordship, the prosecution witness one establishes this composting unit is non-functional for 6 months. 40% of industrial polymers in the biodegradable section were existing when the sample was taken, and this methane accumulation creating a pressure cooker effect was confirmed by the FSL report. This high concentration of methane and toxic leakage were directly linked to the operational mismanagement by the company.
Did you have you taken the names out who visited the company and put their signatures on the all clear logs for the November 2025? You have not done that, and there are allegations of bribery against your officers. I'm not saying your officers are bribed or not. I'm not saying that, but both the company and the state are trying to find the loopholes by not ordering, by not requesting or ordering any kind of inquiry against those officers who are put under allegation of bribery, as the prosecution witness number 3 said.
Your Lordship, if I may.
Yeah.
Under the testimony, under the deposition of prosecution witness 3, Sunita Rao, the names of the TD officers have not been disclosed. However, these all clear logs were mentioned by the employees of the state. And although there has been no clear mention whether there were any consequences, whether there were any chances of bribes being given to the employees in order for the check, or whether there was any violation that were not as obvious to the naked eyes to the prosecutional claim. Both these claims have been made by witness number 3. Although we are not negating her opinion, but the state clearly mentions that it was from their part that they had completed their duty. It was from the company's part that they eventually started this corruption within their system. Corruption as in stopping the composting process, and therefore also this segregation of waste also degrading day by day, and eventually this led to the disaster that was occurred on 14th December.
So somehow you admit that admit the fact that bribery may have taken place. Somehow you admitted.
Your Lordship, the state mentioned that both these statements were made by the witnesses of the state that either they were bribed or the violations were not as obvious to the naked eye of the prosecution claims. This is not this state, however, from their side has said that these logs, these waste that were sent in batches, they were all clear from their side. It is the company's collusion that has led to this.
Collusion with?
Collusion as in what they started with the waste disposal and.
No, my question was on the bribery part. Why not there is any kind of inquiry, any order, departmental proceeding? You did not do that also.
Your Lordship, as far as mentioned in the witnesses statement, only the only this has been mentioned so far. As far no investigations have been started against the officer so far.
So, on your part during the trial, your witnesses and your submissions all are inconclusive. Without that, without inquiry against your own officers.
Your Lordship, the mere inquiry does not satisfy that the batches that were sent by the state were also wrong. It is the duty of the company to start to one by one start saying start stating that what the processes are fair and all these clear logs are valid. There were no bribery and everything, bribery or anything that was not obvious to the naked eye. It should be responsibility of the company to in good faith state that these were indeed all just claims and all these logs were definitely true. Your Lordship, if I may proceed.
Yeah.
Your Lordship, I would like to close my submission on this that we are here because 3 people died, including a child, because an operator of a hazardous landfill facility decided that regulations were paperwork and profit mattered more for Vikram's sake. We are here because 62 other people were hospitalized, as mentioned in the statement of prosecution witness 4. And we are here because the groundwater of 3 villages were contaminated. The wetlands were polluted, and the essential meaning of the rules were rendered meaningless. And we are here because none of these outcomes were accident, and all of them were foretold. And it was the responsibility of Vikram Seth, who should be vicariously liable. And furthermore, he should be the one to take responsibility for the actions. I would like to proceed, give my remaining time to my co-counsel. So, Lordship, much obliged. I rest my case.
You don't rest your case now. Let him submit. Then you rest your case.
I rest my case.
Oh, it's okay.
Ma'am.
Yes, yes.
Your Lordship, the counsel for issue 2 and issue 4 would provide subsequently the learned opposition counsel that the learned opposition counsel provided all rules of solid waste management rules 2016. Your Lordship, solid waste management rule 2016 had been superseded and repealed by 2026 rules under the Environment Protection Act 1986. Therefore, Your Lordship, issue 2 that is contended by the learned opposition counsel does not stand strong because 2016 solid waste management rules have been superseded. Further, Your Lordship, the memorial on behalf of the appellant on page 22 provides issue 2 whether there is a violation of solid waste management rules or not. Your Lordship, entire issue 2 has no single address of a rule under this solid waste management rules of their memorial. Further, Your Lordship, the contention that was provided from the honorable bench to my learned co-counsel, the counsel will proceed to respond that the annexure 2, public witness 1, I would like the counsel would like to state, Ananya Sharma, Your Lordship, I cannot definitely say if the methane alone caused the pressure cooker effect or if the illegal dumping of industrial waste by unknown third parties acted as the primary catalyst. Your Lordship, if the council may refer to Annexure 1 and brief observation by IO, it provides forensic science laboratory reports, states confirm the presence of high concentration methane and toxic like directly linked to the company's mismanagement of biodegradable waste. Your Lordship, reports have a credible power than the Ananya Sharma environmental scientist benefit of doubt that she cannot definitely say or not. Further, Your Lordship, contention of issue 2, whether TDA as an agent and instrumentality of the state is liable to be punished for the blatant violation of solid waste management rules specifically and as an abettor of those offences. It is substantiated in threefold manner, Your Lordship. TDA acts as an instrumentality of the state under Article 12 of the Constitution, and it does not automatically attract violation. Second, Your Lordship, the TDA's failure to provide primary infrastructure segregation amounts to a regular relapse rather than a criminal one. That will be provided. Third, Your Lordship, the TDA's conduct does not meet the threshold and essentials of abatement under Section 45 of the BDNA 2020. Your Lordship, firstly, it is contended that the Article 12 of the Constitution defines the state and includes all local and other authorities. Your Lordship, there was a private partnership agreement between the Municipal Corporation of Tripura and the Green Horizons Developers Private Limited. Wherefore, public was the Municipal Corporation of Tripura, and the instrumentality was the TDA that was provided. How, Your Lordship? It is provided in the R.D. Shetty versus International Airport Authority of India. If it may, Your Lordship, the council may provide the facts if it's necessary. Much obliged, Your Lordship. It provides that deep and pervasive state control may afford or indication that the corporation, state agency, or an instrumentality. This provides on Ajay Hasya versus Khalid Mujib Sehrawadi also. This provides that TDA was an instrumentality of the state. Your Lordship, the contention is that the state does not violate the provisions of this act. It is the TDA as an instrumentality. The state cannot be held criminally liable. It is a TDA that can be held criminally liable according to the law. So further, Your Lordship, it is contended that the criminal liability of a statutory authority as provided requires either a specific deeming provision in the parent or environmental statute or proof of the general ingredients. Your Lordship, the council on behalf of the respondent submits that section 17 provided offences by the government departments. In the present case, Your Lordship, TDA, being an instrument of the state, delivered the mixed waste to the landfill site for month, as was clarified from the co-council. The council would seek permission to provide it, that one claiming that primary segregation infrastructure was under renovation. Therefore, TDA's liability would fall under Section 17 of the EPA, Environmental Protection Act 1986, instead of treating its default as an abatement of Green Horizons developer offense. Your Lordship, the TDA's liability would be channeled under the specific appropriate regulatory framework and not the criminal responsibility that is opposed on GHT. Second, Your Lordship, there is a distinction between administrative default and penal liability. Your Lordship, the PPP agreement, as mentioned before, is a long-term contract between a private party and a government entity for providing a public asset or service in which the private party bears significant risks and management responsibilities, and remuneration is linked to performance. This is cited in World Bank Group, the 27 citation in the memorial provided by the respondent. Your Lordship, therefore, a breach of contractual terms, Your Lordship, term gives a rise to contractual remedies and does not without more translate into penal liability. Your Lordship, when the TDA defaulted providing mixed segregated primary infrastructure mixed waste, it was a contractual obligation that was breached and not a penal liability. How? Your Lordship, there is an absence of clear fraudulent or dishonest intention, and it does not automatically constitute the crime. Your Lordship, an operator, it is a duty to provide due diligence and independent breach by Green Horizon Development that cannot be discharged.
You said you talk about the it's a contractual liability and not a penal liability. When people die, then what happens? It will remain a contractual liability, or it will go to the penal liability as well.
Indeed, Your Lordship, Your Lordship, the contention is there is not a reasonable nexus. The further provided that the mixed waste were provided to the landfill site does not further provide that the third party bunkers and the failure of the Vikram Seth and the company to rely on those mixed waste provided that offense. Your Lordship, there is not a bridge to that offense.
This was not your responsibility to monitor
Your Lordship, the Rule 2 of Solid Waste Management, Management Rule 2026, provide on page 5 of the provisions, rules, and statute which the Council has provided. It is highlighted, Your Lordship, the rule does not cover industrial waste or hazardous waste. Your Lordship, the hazardous waste monitoring that was in the clause is a contractual obligation that was breached, and that is accepted by the TDA. But provide that the rules and the statutory guidelines, it is hazardous waste is not provided in the Solid Waste Management Act rules, which is further in Environment Protection Act. Your Lordship.
If the private agreement causes the public nuisance, will not the company or the persons who are involved therein will make responsible?
Your Lordship, there must be a reasonable nexus between the bridge as further provided. The TDS default, if at all.
Are you answering my questions or you are narrating or explaining my point?
I apologize. The council apologize, Your Lordship. Your Lordship, clause 3.1 of the ZG of the Solid Waste Management Act rules provide, Your Lordship, as further provided that there is not a reasonable nexus and the reasonable bridge.
First of all, try to satisfy that if there is a private agreement between two parties which causes the public nuisance, will these two parties will be held responsible?
Much of indeed, Your Lordship, but
Yes or no?
indeed, Your Lordship.
Yes. So in this case, 2 persons have been injured and 3 were dead. Is it only the company who are responsible, or TDA will also be called as a contributory negligence?
Your Lordship, the council will take few moments to gather the points. Your Lordship, if I may. Your Lordship, the rule 3.1 ZG, if the Lordship provide me, operator of a facility means a person or entity who owns or operates a facility for handling solid waste, which includes the local body and any other entity or agency appointed by the local body. Your Lordship, here the operator, the person was GHD. Provided, Your Lordship, the duties of the operator in 7B and G of the solid waste management rules ensure that the treatment standards are such that no harm is caused to human health or environment and shall meet the standard as laid down in Schedule 2 and Schedule 3. Your Lordship, the mixed waste management that is indeed accepted by the state provided. But after that, the duty of the operator was there, and the PPP agreement, the larger duty compiled to the.
Paid. I'm agreeing that okay, company has paid. Are you puncturing your own performance of your duty?
Your Lordship, indeed, the council would actually accept the council, learned. Your Lordship, the thing, the Lordship, provided that it is a, Your Lordship, it is a. Yes, we are, Your Lordship. The thing is, Your Lordship, the appeal filed by appellant under 415 BNBS, wherein the GHD and the Vikram said CEO has been convicted. Your Lordship, the fact that the state has come forward to approach the honorable court is that Your Lordship, that appellant is a convict under this section or not. State has its own liability, Your Lordship, but the contention here is about the appellant CEO Vikram Seth and the GHD, which was the operator and did not comply to the duty. Your Lordship, even if we accept, Your Lordship, that the mixed waste was provided, after that, the Vikram Seth, he did not comply to the thing. After that, the regular checks were not maintained. Your Lordship, mere responsibility from the TDA that was primary secretary infrastructure, which, Your Lordship, we failed. But the subsequent failure of the GHD and the subsequent third-party bunkers that were provided did not hold state further liable.
If you would have segregated and if you have not provided the mixed waste there, then this incident would not have taken. There was no question of making segregation because this could not have taken place. So there was a failure, primary failure on your part, which subsequently the company has also failed. So combinedly, both of you have contributed and injured 62 persons' lives, and you have taken 3 persons' lives.
Your Lordship, there was no complaint made by the Green Horizon Development. CEO provided the CEO Vikram said provided the mixed waste should be provided in the compost pit, and the segregating function should not be stopped. Your Lordship, Therefore, it's not the only state that is liable. It is the further weightage that is given to the GST, the CEO.
Right. Not only the state can be held responsible. I'm also agreeing. But are you agreeing that yes, the state should be made responsible? Then only the second part can be clarified from this bench.
No, Your Lordship.
You yourself accept that the state can be held.
Your Lordship, the gravity of the offences provided that the state is liable to the statutory EPA guidelines and the contractual obligation that was provided in the PPP. Your Lordship, the CEO is the, Your Lordship, if I further proceed to issue 4. If we apply
To issue 4. Your issue is
issue 3, issue 2 and 4.
issue. Okay, come to issue 4. What is the last issue? No?
Yes, Your Lordship.
Whatever issues you are dealing with,
Issue 2 and 4.
what issue, issue 2 and 4, whatever you have your submissions from now onwards, you'll be keeping in mind 2 words. State has monitoring and supervision. Fine, keeping that 2 things in mind, supervision and monitoring, you make your entire rest of your submissions.
Your Lordship, the respondent would provide that as an operator, it is the duty to provide due diligence and independent breach by GSD that cannot be discharged at THD's parallel default that the council accepts. A competent operator should have visibly refused any unsegregated waste. Your Lordship, it was not necessary to accept the waste. The moment the GSD knew about the mixed waste, they should have refused to accept it, failure of which produced a causal link between the fire caused and the appellant's non-compliance. Your Lordship, most importantly, to respond to Learned Opposition Council, PW5, Annexure 2, Your Lordship, that several notices by GSD were sent to Municipal Corporation requesting funds for composting unit repairs. Your Lordship, the fact provides that within the contract, TDA, as an agent of Municipal Corporation, was responsible for the segregation before the waste reached the landfill site. So, Your Lordship, the mere fact that the that the Municipal Corporation was requesting for funds for the composting unit repairs does not stand strong, because primary segregating infrastructure before reaching the landfill site was within the contract, and there wasn't any providing and reimbursing the landfill site within the GST's company. Your Lordship, second, PW3 Annexure 2 side that provided machinery was broken and Vikram Seth diverted funds to other projects. Appellant asked for funds for composting unit repairs and has sufficient funds to divert certain for other projects. Your Lordship, PW3 provided that machinery was broken and Vikram Seth asked for funds. And subsequently, he also diverted those funds. Had it been that the fund, there wasn't any criminal intention of Vikram Seth, those funds could be diverted through the machinery that was broken. And why was they diverted?
Why the statement of PW3 can be undertaken by the why the board would rely on our statement?
You are relying on PW3 partly or fully?
Fully, Your Lordship.
Fully. Okay.
Your Lordship, the present case, the learn about Your Lordship, the law on entrusted witnesses in India does not exclude; it scrutinizes. The Supreme Court in Vedivelu Thevar versus State of Madras held that the testimony of an entrusted witness is not to be discarded solely on the ground of arrest. The court must carefully scrutinize it, and found reliable and corroborated may act upon it fully. Your Lordship, it is reliable because the internal memos, as referred by the PW3 testimony, it provided, Your Lordship.
PW3 is still herself is questionable because the action was taken against her. So out of agony, anger, she is giving all this statement.
Your Lordship, but the internal memo that she provided.
Yeah, it is only in her statement she is making that there was an internal memo. But on record, you have not put forward like like in FIR, no? FIR, all these things are mentioned. In PW3, whatever he is mentioning over here, has he submitted any memo before the court?
PW3. Just now you have said you have been the state council.
I have internal memory. It was not brought
No, that is true. Further that, he's a state council, and on behalf of the state, he has stated that he. My question was previously that whether he agrees to the statements given by the PW3 entirely. In that case, the state officers were bribed.
all clear log. Yes.
State officers were bribed. You did not take any action against them. You fully agree with the statement of PW3.
Your Lordship, that is alleged state of bribe.
Where is and alleged is different. That is alleged, fine. But she said either they were bribed. You agree to that?
If the council,
Yeah.
Your Lordship, the moot proposition that provides that alleged and that they were bribed is out of the moot proposition. The moot proposition that provides is that the signature was
This testimony is PW3. It's part of the moot proposition only.
Your Lordship, that the bribe thing, it is out of the moot proposition, and
No. When you are provided the statements of the witnesses, it is part of the moot proposition.
Your Lordship, but bribed.
Yeah, bribed. You are accepting it. You are accepting it. Bribing.
So we have taken into consideration what is said. So in her statement, she is mentioning over here that either they were bribed or violation were not as obvious to naked eye as the prosecution gives.
Your Lordship, the evidence of bribe is not in the prop. It is only alleged. If the learned, Your Lordship, would provide in PW3.
So PW3 statement is not correct regarding this bribe.
Your Lordship, it is partially correct. This all clear logs on the
You are changing your statement.
No, you are stating statement. Because you said to one of my colleague question, you agreed that yes, in entirety you have agreed with the statement of PW3.
Your Lordship, the contention is that the state relies fully on PW3, Ms. Sunita Rao's testimony. How? Your Lordship, the internal memos are accepted by the state. The signature on the all clear logs for November 25 is also accepted by the state. There is no contention from the state and no acceptance that they were bribed. The signatures or all clear log was a systematic default on behalf of the state, Your Lordship. Therefore, the state does not contend that it is the state or the officials were bribed, Your Lordship. The moot proposition does not cite that thing. That is alleged.
Yeah.
Your Lordship, we have to the council have to entirely believe the moot proposition that has been given. Further, Your Lordship, the TDA does not satisfy the statutory test for abatement given in the issue 3. Your Lordship, it is contended that the essentials of the abatement, section 45, include provided in page 1 of the provision of statutes, instigation, engaging in a conspiracy, or intentional aid by an act or illegal omission, all coupled with the knowledge or intention that the act abated would constitute an offense. Your Lordship, if we apply the ingredients of abatement in the present case, the TDA's omission was disclosed only through internal audits, which surfaced recently, which was not a concealed fact. The TDA itself claimed the fact that primary segregation infrastructure was under renovation. A party that rings the alarm cannot be convicted for the fire. Your Lordship, and for the conspiracy, there must be other person as an essential that has been conspired or abetted, Your Lordship, and therefore the essential abatement does not satisfy, which is the contention of the issue 2 at hand. The present case is silent upon that the TDA had the knowledge about the mixed waste that was reaching the landfill site and would combine with the illegal dumping industrial chemical waste to cause a methane explosion. Your Lordship, there is a far-fetched provided forcibility of the specific harm is essential for abatement. Therefore, as an illegal omission amounting to abatement requires the omitting party, Your Lordship, to be under legal duty and to have a requisite knowledge about that omission that has been done by them, and it would facilitate that specific offense. Therefore, Your Lordship, in the present case, there was no forcibility as to the omission on the part of Tripura Development Authority. Tripura Development Authority's continuing and pre-existing practice is at worst a mere breach of contractual obligation under PPP, and which cannot be foreseen because of the causal chain of action, Your Lordship. Therefore, it is not intentional facilitation of a fire. Nobody could foresee. Further, the true intervening cause was the illegal dumping by unknown tankers, a third party criminal act outside TDA's knowledge or control, which TDA cannot be said to have abetted. Your Lordship, shifting blame to TDA would distract from the GSD's own direct license statutory non compliance. Your Lordship, it was the methane and composting management that failed, and within the GSD. The causation, in fact, regarding the TDS mixed waste contribute to the methane buildup, which must be differentiated from GSD's own penal liability. There should be a bridge to those acts. If the Lordship is satisfied with issue 2, the Council should approach to issue 4 at hand. Your Lordship, it is submitted that in a threefold manner. Issue 4 provides whether the CEO, Mr. Vikram Seth, can be held vicariously liable for the deaths caused under the principle of alter ego, or if the failures were purely systematic or institutional, for which the company as a juristic person can be held liable. Your Lordship, it is substantiated in a threefold manner. First, there is a distinction between directing mind and will and reverse alter ego. Your Lordship, second is there is a non-delegable duty on the CEO under Companies Act and EPA. Your Lordship, the corporate veil must be lifted where the corporate form is used to evade penal consequences for a personally traceable act. The case arose from, Your Lordship, it is contained in Sunil Bharti Mittal, which facts provide that the case arose from high-profile 2G spectrum allocation, provided there were irregularities, and Sunil Bharti, being the directing mind and will was of the company, was held responsible. Your Lordship, the Supreme Court clarified the flip side of corporate liability. It established that while an individual can impute criminal intent to a company, one cannot conversely hold a director vicarious liable for a company's crime. Your Lordship, therefore, however, in contrast, the present case does not rely on Mr. Seth's resignation as CEO alone, but also relies on PW3's direct first-hand eyewitness account of a specific personal command as accepted by the state, because it is a prosecution witness, Your Lordship, whereby it states that Seth ordered to stop the segregation process to speed up waste disposal and told employees regulations are just paperwork. This is direct evidence of Seth's individual act and individual mens rea. Therefore, concrete evidence directly implicating him in the commission of the offense in the Sunil Bharti case itself states that it would justify proceeding against the individual. Your Lordship, the doctrine is not being reversed, the alter ego, but being correctly applied. Seth's directing mind, where he ordered to stop segregation, is attributed to the company, making the company liable to. Your Lordship, the acts of the CEO satisfies mens rea rather than a systemic failure. It is humbly contended that in Iridium India Telecom Limited versus Motorola Incorporation, Your Lordship may refer on page 4 of the case sheet. A company can be a victim of deception. It cannot be perpetrator of deception. Your Lordship, instead, it ruled that criminal intent and dishonest representations of a company's directing mind and will, herein Vikram said, are directly attributed to the company itself. Your Lordship, the doctrine of directing mind and will established that a corporation can only be directly liable for a criminal offense. In the present case, Your Lordship, Vikram Seth had a personal knowledge of non-compliance. Your Lordship, the PW3 and Exer 2 provides that I resigned in October 2025 because the CEO, Mr. Seth, ordered us to stop the segregation process to speed up waste disposal. Your Lordship, he told us that the regulations are just paperwork and I have internal memos. Here, funds were diverted to other work and funds were requested through notice for composting unit repairs. Your Lordship, why were the funds transferred in other projects when the first instance, if the company was requesting funds for an year? Your Lordship, the systemic failure, the defense on these facts does not stand for a documented personal decision. Seth cannot claim a systemic failure when the system failed because he personally ordered the relevant safeguards to be switched off. Therefore, Your Lordship, the corporate veil must be lifted. It is humbly contended that the doctrine of separate corporate personality in Salmon versus Salmon, the 1997 case, it provides a separate corporal personality. It is not absolute and may be disregarded where the corporate form is deployed as a cloak of evade liability, which is personally traceable to individual in control. Your Lordship, in the present facts, Mr. Seth, whose specific operational instruction precipitated the violation, his disposition as DW1, wherein he sought refuge in the plea that the company is a separate juristic person. Your Lordship, as further contended, it is a direct evidence and the direct acts of the Vikram Seth as just justified from the mens rea. However, in the TDA, there were regular compliances that were not met. However, there's an instigation and there's an intention of Vikram Seth. However, in the TDA, there's not intention, they're mere non-compliances of the duty that was provided in the contract. Accordingly, Your Lordship, the corporate must meet peers and personal penal liability fastened upon the appellant for the breach directly occasioned by his own act and instruction. If Your Lordship is satisfied, issue 2 and 4, the council will seek permission to proceed to prayer. Wherefore, in the light of the facts present, issues raised, argument advanced, and authorities cited, it is most humbly prayed before the Honorable High Court of Tripura that the High Court of Tripura may be pleased to dismiss the appeal filed by the appellant under 415 BNVS, uphold the conviction recorded by the Sessions Court under section 105, 270, 280, and 287, declare the acts of the accused satisfy the ingredients of culpable homicide under section 105 BDNA, hold that the logbook B and CCTV footage seized by PW5 are admissible in evidence, declare that the appellant is personally liable for breach directly occasioned by his personal act and instruction, and or Your Lordship, pass any other order, direction, or relief that it may deem fit in the best interest of justice, equity, and conscience. For this act of kindness, the respondent shall duty bound forever pray. Your Lordship, the respondent may rest their case. It was an honor pleading before the honorable bench. Much obliged, Your Lordship.
Thank you, counsel. If permitted by the honorable bench, may we proceed with the rebuttal and the rebuttal now? Much obliged. If the learned counsel for the petitioner wishes to accept the reserved right of rebuttal.
The bench is also opinion that during the course of arguments, the bench has placed many questions and that could have satisfied us regarding question regarding the rebuttal liability. So we should refrain from doing that. Okay. Rebuttal, we are doing.
The oral submission for the final round has concluded. I request that teams to be seated until the honorable bench complete their portion.